You're listening to the Hour of the Time. I'm William Cooper. Good evening, ladies and gentlemen. Tonight is a live broadcast, and I am going to start to teach you things that I have never taught you before. And in fact, when you would call and ask me, I would just refuse to give you the answers for good reason. For good reason. You see, most people are looking for some kind of a silver bullet. They're looking for a form to fill out that will cure all their ills, and there is no such thing. There are methods, techniques, structuring that you can become involved with if you know and understand the law that can protect your assets for your children, for their children, for your great-great-grandchildren, for what the Founding Fathers would have called our posterity. Those who are yet unborn, but will, as sure as the sun will rise tomorrow morning, be here at some time in the future. They are our heirs. Those who do not plan properly do not pass down anything to their children or their grandchildren or their great-grandchildren. And those who think they've planned properly, according to the way the powers that be wish you to plan it, end up losing at least 50% of what they intended to pass down in estate taxes, inheritance taxes, fees for people to take care of all of that stuff, lawyers, and if it's contested by anyone, oh yes, it gets eaten up very quickly, going through the courts, and most of the assets disappear into the deep pockets of those liars that we call lawyers, those leeches upon society. There are steps that you can take now to protect your assets so that this does not happen, so that your death is nothing more than the sadness in the hearts of those who loved you and an obituary in the local paper. And that's as it should be. If you led a good life and you contributed to the welfare of the community or of the nation, then you will be remembered for as long as there is a record of your contribution. And we don't need to ask any more than that. So, you want to prepare your assets, you want to prepare yourselves, and you want to prepare those whom you will be passing these things on to as beneficiaries in some manner to take on the responsibilities that will be necessary. And you have to learn how to do all of this. And if you don't do it, then you're just another dumb American who's forgotten the concept of family and really doesn't care about those who will come in the future, or maybe have already been born, except for the love that they give you. I have sat at tables across this country and listened to Americans bitch and complain about people who, operating as families, have purchased local businesses and built empires right under their nose. Some of them were immigrants from other countries who understand the concept of family. And I sit patiently and listen until eventually I lose that patience, which is not very difficult when you know what I know and have been around as long as I've been around listening to all of this kind of crap. And then I have to say, what steps have you taken as a family to build a business or an estate to pass down to your heirs. Oh, well, we really haven't done anything like that. Our family's not too close. Then how dare you criticize families who do, no matter where they're from or how long they've been here? They understand the family concept, and if you don't, you're doomed to failure. Your family. The reason that many of you are poor today is because your mothers and fathers, your grandfathers and grandmothers, and your great-grandfathers and great-grandmothers did not understand, appreciate, or care about the concept of family either. Did not protect the assets to hand them down. Or if they did, those to whom they were handed down in whatever method it was accomplished did not take the necessary measures to protect those assets and preserve them for future generations, and in fact, to make them grow. So, I'm going to begin teaching you some things tonight, ladies and gentlemen, that you need to know to make these things happen, to be able to take care of your assets. But let me preface all of this with something that I think most of you are going to understand. If all you care about is yourself, turn off your radio right now and go do something else, because you're not going to be interested in hearing what I have to say. If you love your children, if you love your grandchildren, if you love your great-grandchildren and your great-great-grandchildren, even though they may not even be born yet, if you care about them and if you care about the future, if you care about your posterity, if you care about your family, if you care about your personal gene pool, then you should have pen and paper by your side and you should listen very carefully. Most people make the mistake of thinking the grass is greener on the other side of the fence. There's something out there that if you could just get to it, your lives would be better, and I'm telling you, that's just the biggest crock of crap. It's a method of rationalizing your failure in what you are doing now, or in rationalizing your continuing to fail, rather than looking for a method to succeed. So you must stop that kind of thinking. There are plenty of rainbows, ladies and gentlemen, that there is absolutely nothing on the other side. I'll tell you why you can't, ladies and gentlemen, because it's a fantasy. There's nothing on the other side of the rainbow. There is no pot of gold at the end. This is the trap, the great trap that socialists fall into. They hear this promise of Karl Marx that if they fall into line and promote world socialism, that someday they will find that paradise over the rainbow. They will find that pot of gold. They will be taken care of always. It will be the end of the sadness of the common man. And it's just not true. It is a beacon for failures. It is a place where those who are parasites, who do not wish to work, who do not want to perform the necessary study that would lead to an education that, if followed by a diligent, and I mean diligent, loyal program of work, either in your own behalf, at your own business, or for someone else, to at least a measure of prosperity which is above that of those who cannot or will not do those things. All men and women have a brain. Most, and I mean most, men and women have the same capacity to use that brain. There are some people, because of a problem in the formation in the womb, or during the birth process, or because of disease afterward, or handicapped in some way. These people are the very small minority. And yes, someone must take care of them, or at least take care of them and guide them until they are able, and many of them become able, to go out and live on their own. And if they can do it, you can do it. Many of them found their own businesses, and if they can do it, you can do it. Most people never learn how to protect their assets. Now, what are assets? Before you can even begin to understand what it is that I'm talking about, you must understand what an asset is. Assets are things that you possess that have value. An asset can be your job, which, as long as you hold that job, will bring in X number of dollars every 2 weeks or every month or every 15 days or however you're paid, or every Friday in some instances, and some people are even paid every day. That's an asset. If you lose your job, you have lost an asset. Asset is savings. An asset is property that you own, or think that you own, or at least can sell to get something that you can convert into an asset. An asset is anything that has intrinsic value or that can produce in some way intrinsic value, meaning money. Federal Reserve notes are not money. But that's for another night. In fact, we've covered that many nights already. Now, I know that most all of you are tired of increasing taxes and government regulations. We've reached the state where there are so many taxes and so many regulations that it has gone beyond tyranny. Many of you are earning much more money than you ever have in your life, but you get to keep less of it because of inflation and because of taxes. And I can remember a time not too distant past when only one of the adults in the family, one of the married couple, had to work and could, with their labor, support the family very well in the middle income bracket. Now, that's impossible. And usually the mother and the father must work. And as soon as the children are able, they've got to go to work too. If you own property, if you drive an automobile, you've got to be concerned about a potential lawsuit. If someone falls on your property and is injured seriously, and sometimes even not seriously, some people can fake a serious injury very well, you may lose everything that you have earned in your life up to that point because of legal action taken against you. You all know the potential of causing serious damage to property and injury to your fellow human beings when you drive a car. And how about creditor action? What if you were to lose your job? And all of a sudden, those to whom you owed money, I should say, came after your assets, your home, your automobile, which you need to get another job and go to work, the money that you have in investments or in savings accounts or in T-bills or whatever you have that money in. Have you ever seen someone you know completely financially ruined by a divorce settlement? They were doing fine until all of a sudden something went wrong in their personal relationship and there was a divorce. And you know who it is that always gets ruined, especially if there's children in the family. When it comes to that, fathers have no rights anymore in this politically correct society. It's as if women became pregnant and gave birth by themselves, and fathers have nothing vested in the children, don't love their children, don't care about their children. The children have none of their father's genetic material in them, which is all a bunch of hogwash. Are you concerned about the loss of privacy and confidentiality in your personal and business affairs? Well, you should, because in this age, privacy is almost non-existent. Would you like to experience personal and financial freedom beyond your wildest dreams? If you would, I'm going to teach you how to do it beginning tonight. Would you like to see your assets grow without fear of lawsuits, creditors, ex-spouses, or a debt-ridden government stealing was rightfully yours? If your answer to all of these questions is yes, then pay very close attention, ladies and gentlemen. Every single day, our debt-ridden government is becoming increasingly intrusive into our personal and business affairs. Sophisticated computer databases are being set up to pry into every aspect of our lives, particularly our finances. And most of us, being naive and innocent, freely volunteer whatever kind of information is asked of us, and without even knowing it, help build those databases that in the future will be used against us. And why is this happening? Because the government is in a feeding frenzy. They need more and more and more to pay for the enormous debt they're piling up day by day by day by day. You see, this is a debt-based economy. A dollar cannot be put into circulation unless it is first borrowed by someone. Did you know that approximately 46 cents of every dollar that you earn is gobbled up by federal and state taxes? And most people hate to admit it, but would have to say that they work for 5 or 6 months every year just to pay their taxes before they can put a single penny in their pocket. And that's a conservative estimate, ladies and gentlemen, because there are many taxes that are hidden. You don't even know that you're paying them. For instance, when you buy a loaf of bread and you pay the sales tax on the bread, if, say, bread is taxed in your state, did you know that the wholesaler already paid taxes on the ingredients to make that bread? Those are hidden taxes. And if we can accept 46 cents of every dollar going to taxes, that leaves only 54 cents out of every dollar as spendable income for you and for your family. Now, is it any wonder why you are feeling more and more financial pressure? How in the world can we live under such a terrible burden? Decades of deceit and overspending, the need for billions of dollars to fund entitlement programs, and an ever growing in size government, state and federal. State and federal. Until we reach a point where most of the people in this country are working in some capacity, either directly for or in support of the federal government or state government, It's a joke to believe that you're being paid a salary, because 46% of your salary is being paid by you. Don't you understand that? We're being strangled, ladies and gentlemen. And people keep thinking they're getting something for free. Nothing is ever free. And the government does not have a penny that did not come from the people. And there is no end in sight. Government will not get smaller. It can only grow in size. It can only increase its thirst for power and its greed. As long as there are government employees and beneficiaries with a vested interest in their continuance, these programs will continue to expand and grow. We not only have a nation that is being taxed at the highest rate in history, but one where its citizens are willing to give up their Second Amendment rights as well as their constitutional rights, or I should say their God-given rights protected by the Constitution to freedom, privacy, work, independence, and self-reliance, for more and more government control. Why? Because they really honestly believe that they're going to get taken care of. They're going to get free things from the government. Not understanding that the government cannot give out anything for free. It all must come from somewhere, and every penny comes from you and me. And everyone working for the government and everyone receiving the entitlement programs. And if everyone overnight were to stop working and go on the dole, there would be nothing for anybody. But every day, an increasing populace believes that they're going to get something for nothing. More and more government control. Have you ever wondered that maybe taxation without representation might be cheaper? It's possible. You see, it wasn't always this way, ladies and gentlemen. This is not the United States of America that the Founding Fathers left to their posterity. When Columbus landed, we doubt the Arawaks appropriated a monthly wampum payment to subsidize his living expenses. And when our ancestors arrived at Plymouth Rock to face a cold and hostile environment, there was no one from social services there to greet them. And when millions of poor Germans, Jews, Irish, Italians, and Poles migrated to the United States, there were no entitlements, and none were expected. And even if they were available, 99% of all those people would not ever have gone down and made application for 1 penny because they were born into what is known as the work ethic. They were proud. They wanted to make their way. And people got along. They worked, ladies and gentlemen, because they had to work, they wanted to work, they were taught to work, they knew how to work, they weren't afraid to work, and they prospered. They prospered. That's why this was, until all of this socialism crept in, the greatest nation on the face of this earth, the place where people dreamed of living. The very first entitlement program to come along for all Americans was Social Security. And originally it was set up as a self-funding old age pension, so that when people got old, they would have a source of income. It has never been a trust. There is no trust fund. And if you don't believe me, all trust funds are listed in the law. Go and find it. It's not there. I can remember when my grandmother began paying into Social Security, she thought it was the greatest thing in the world because now she did not have to save or invest for her old age. What a terrible mistake. And me, being such a young boy at the time, didn't understand a word that she was saying. If I had, I would have advised her not to participate. Of course, the government couldn't resist borrowing, or actually, they never borrow, they just take it, because it's never paid back, ladies and gentlemen. Not one penny has ever been paid back from money that was taken, that was paid in by people through their paycheck, the Social Security tax, and that's what it is. It's a tax. It goes into the general fund, and it's spent wherever it's needed. And the government has used that money over all these years, while at the same time providing increased benefits to the participants. The end result is the Social Security system is broke. Been broke for a lot of years. They don't want you to know that, so they continue to borrow money so that they can send out those checks. And they keep talking about the trust fund. There is no trust fund. Never has been. A typical retiree on Social Security will receive his or her entire lifetime Social Security contributions, inflation adjusted, in less than 2 years of retirement. Bet you didn't know that. In addition, the average retired couple will receive $100,000 or more in Medicare coverage than they paid in Medicare taxes. So it really doesn't make any difference if there's a Social Security trust fund or not. 2 years after you retire, you've used up everything that you paid in. And so where does the balance come from? It comes from everybody who's working at that time. But nobody is told these things. Essentially, the Social Security system is funded through the use of a pyramid or a Ponzi scheme. Now, a Ponzi scheme, ladies and gentlemen, is a scheme that spends money from new participants to pay benefits already spent and owed to the previous participants. Have you ever heard a better definition of Social Security? And if that weren't enough, the government has done the same thing with the federal employee pension funds. They do not have the money put aside that must be paid to future retirees. In reality, ladies and gentlemen, the unfunded entitlement programs such as Social Security and government pensions are not trust funds. They are pay-as-you-go pyramid schemes. And if the government were a private firm, it would be required to have the pension money in the bank. You see, it's illegal to run a Ponzi scheme. It's a felony. If a private firm, you or me, or any corporation or business that we controlled were to behave like the government, we would be charged with fraud. We would be brought before a court. We would be tried. We would most likely be convicted, and we would be sent straight to prison. In addition to uncontrolled spending and entitlement programs, the government is also growing exponentially through sheer incompetence and bad management, not to mention the billions of tax dollars that will be needed to finance the war on drugs and the war on crime and billions of dollars worth of bombs dropped on places like Yugoslavia. I'm going to read you an article from Reader's Digest that was published in September of 1994. Listen closely. Ever wonder why middle-class families find it harder to make ends meet? Taxes are the reason. Today, the average family of four pays over 20% of its income in federal taxes and Social Security. Since 1948, the percentage it pays in federal income tax alone has nearly tripled. The eroding value of the tax exemption for dependents is one of the tax code's anti-family bias. In 1948, the exemption shielded 69.2% of the median income for a family of 4 from tax liability. By 1992, it protected only 20.6%. In 1992, a family of 4 could exempt only $9,200 from its taxable income. But if the dependent exemption had been worth as much in 1992 as it was in 1948, that same family would have been able to exempt $30,873 from their income. In 1948, the typical home had only a single wage earner. Today, in the majority of households, both husband and wife must work to maintain a comparable standard of living. Now imagine, if there were a legal, effective means to reduce your tax liability by even 10, 15, or 20%, it would be like receiving a comparable pay raise. You would realize an increase in your after-tax income for the same time and effort you are applying now. That's the end of the article. But what Reader's Digest did not write about is the fact that most Americans who are citizens of and reside within the territorial boundaries of any state, who do not work for government, are not required to file and pay income tax. There is no law that's ever been passed by Congress requiring any of those people to file and pay an income tax. It's a scam. On top of that, it has been proven, and proven beyond any shadow of any doubt, that the 16th Amendment to the Constitution for the United States of America, which the Internal Revenue Service bases its authority to tax the income of Americans living within the states, was never ratified. It's not an amendment at all. It's a lie. Remember Judge Learned Hand? He said, and I quote, "Anyone may arrange his affairs so that his taxes shall be as low as possible." Now listen to me very carefully. Here's what he said, and it's been ruled by the courts many, many times. This is a fact. Anyone may arrange his affairs so that his taxes shall be as low as possible. There's not even a patriotic duty to increase one's taxes, end quote. So it's lawful and legal to avoid taxes by arranging your affairs so that they do not fall in to the scam known as the income tax. Over and over again, the courts have said that there's nothing sinister in so arranging one's affairs so as to keep taxes as low as possible, and anyone can do it. That's what I'm going to teach you. The IRS's handbook for special agents says, quote, "Agents, our tax system is based on self-assessment and voluntary compliance. The material contained in this handbook is confidential in character. It must not, under any circumstances, be made available to persons outside the service." Wow. I wonder why. Folks, when government takes responsibility for people, then people no longer take responsibility for themselves. George Pataki said that. He was once the governor of New York. So, we must change what they now call the paradigm. Because to change the paradigm, we must come up with new ideas. New ideas produce new results. A paradigm is simply the way we, as a society, look at things around us. It is the sum total of our beliefs about the way things are. Remember, in my book, I warned you that there must be a paradigm shift in the way that we think in order to survive what's coming. A paradigm is the sum total of our beliefs about the way things are. Unfortunately, things are not always what they seem. And now, in what is truly the age of deception, very little is really what it seems. Our view of reality is often distorted by false information. Dr. Robert Anthony, a well-known psychologist and author, calls this the carbonized crap theory. It goes like this. From the moment we are born, there's a bag of crap waiting to be put into our brain. As we hear ideas, crap is poured into our head and stuffed in there by authority figures. These are the people who have a vested interest in making sure we believe what they tell us. We hear it from our parents. We hear it from our teachers. We hear it in church. We hear it from big business, political groups, self-interest groups, and, of course, the government. And that's why my favorite word, ladies and gentlemen, you all know what it is, so everybody repeat after me. Bullshit. That's what's in that bag of crap. And somewhere along the line in our lives, that bag of crap is transferred into our cranium, where unless we take great pains to remove it and replace it with what's known as truth, it stays there. And we are ripe and, in fact, develop a great hunger for more and more bullshit. They're all taking turns packing all this bullshit into our head. And eventually, not too late in life, the crap they've been packing into our head becomes so thick it's impenetrable. And anything that is real or true doesn't get through. It can't. It can't get out and it can't get in because the crap becomes carbonized like a diamond, the hardest substance known. And this forms what is known as a set of paradigms. Once we decide to consciously change a paradigm, we start to get little cracks in the carbonized crap in our brain. We start understanding what is important, what is real, and if we keep at it, eventually we can penetrate through all the crap. But ladies and gentlemen, we have to be willing to challenge our beliefs. We must challenge authority figures and those who want to control our lives if we want to ever know the truth and live our lives according to that truth. The paradigm of the 90s is government knows best. Let the government run it or fix it because you don't know anything. You're irresponsible. If it's left up to you to take care of your life, you're going to screw everything up. That's the socialist paradigm. Did you ever notice that as soon as the government touches anything, it immediately starts costing more? And so the question must be asked, do we want to continue on this path, or do we want to take back our right to make our own decisions when it comes to how we are going to spend our hard-earned dollars? You see, it's time that we change the paradigm concerning the way we look and feel about the role of government. Our new paradigm should be one of personal responsibility, privacy, and freedom. And freedom requires the willingness to die for it, because if you are not willing to die for freedom, you cannot ever have it. You will not ever have it. It will be a joke in your life. The dictionary, ladies and gentlemen, defines freedom as exemption from arbitrary control, independence, the power of self-determination. And this includes freedom from excessive taxation and government intrusion into your financial affairs. In short, you must learn to legally protect your assets from the government bureaucrats who want to take your money and redistribute it to those whom they feel deserve it. Have you ever taken a look at those whom they feel deserve it? And so because of this, you and your money and all your assets are in a terrible, terrible danger. Our debt-ridden government is not the only one who wants to share in the fruits of your labor. If you accumulate wealth, you are a prime target for lawsuits from employees, ex-spouses, customers, competitors, creditors, relatives, and anyone else who feels they're entitled to your assets. And if that's not enough, a sudden turn of bad luck in health, business, or personal finances could push you into bankruptcy. Just a little accident. You and your family could lose everything you have ever earned in your whole lifetime. Why? Simply because you did not set up a financial asset protection strategy in advance. Now, if you think this is all a bunch of crap, listen to me, ladies and gentlemen. Why do you think it was that the family of Mary Jo Kopechne did not sue Ted Kennedy? Let me ask you that again. Why in the world do you think the family of Mary Jo Kopechne did not sue Ted Kennedy? Now, some of you may not even know what I'm talking about. Ted Kennedy is a senator from the state of Massachusetts, a United States senator. He attended a party once late at night where this young woman, Mary Jo Kopechne, was also in attendance. When he left, he was drunk. And Mary Jo Kopechne asked him for a ride. He drove the car off a bridge in the middle of the night. He got out of the car. She was still in the car and drowned, died. He made no attempt to try to help her or rescue her. He made no attempt to flag down a car on the highway to get help, to get her out of the car that sank beneath the water. Instead, he thumbed a ride, went back home, changed his clothes, called all his lawyers and the important people in his family, and did not even notify authorities that Mary Jo Kopechne had gone under the water in that car for over 12 hours. Now, if you think that they could not have won a lawsuit against him for many, many, many millions, maybe hundreds of millions of dollars, then you're not playing with a full deck of cards. But why didn't they sue him? It's very simple, ladies and gentlemen. The very rich and powerful learned these techniques many years ago. And just like me, Ted Kennedy owns absolutely nothing. They couldn't even sue the owner of the car because the car was in a trust in which the car was the only asset held by the trust. Ted Kennedy had no money, earned no money, had no savings accounts, no property. He was bulletproof. Mary Jo Kopechne's family could not sue him because it would have been pointless. It is absolutely futile to sue someone who has nothing to get. And in fact, no lawyer would even take the case, simply because even if they won in court, they could not even get paid, because there's nothing to get from the person who loses the suit. So Ted Kennedy and his entire family set up financial asset protection strategies in advance, and because of that, he suffered no loss. Unfortunately, most individuals and families have no financial protection whatsoever because, one, they are ignorant. They do not realize they need financial protection. Number two, they are optimists. They believe that they will never need financial protection. And number three, they are procrastinators. And most of you listening fit into that category. You know you need financial protection, but you're just too damn lazy to do anything about it. Lawsuits, business failure, tax troubles, divorce, creditors, catastrophic illness, and more can wipe you out literally before the sun rises tomorrow morning, and it will happen to someone listening to this broadcast tonight. That's how bad the odds are. So you must protect yourself by setting up a financial self-defense plan that protects everything you own against any legal or financial threat under any circumstances. And I'm going to be teaching you that tonight and over the next, I don't know how many broadcasts until I'm finished. I'm going to teach you what I know. And I'm going to begin with the admonition that unless you go and study the law, unless you look up and validate everything that I'm going to tell you, you will never know if I made a mistake or if I intentionally lied to you or intentionally deceived you. You will just never know it. Listen to everyone, read everything, believe absolutely nothing unless you can prove it in your own research. And when it comes to your assets, if you don't do that, you're a fool. You cannot believe me or anyone else without validating what you are told. I'm also going to tell you that this is not legal advice because I am not a member of the legal profession, and according to the law, only the legal profession can give you legal advice. What I'm doing is telling you what I have personally learned, and you can benefit from it, or you can turn off your radio and not even listen to it, or you can throw it in the trash can. But whatever you do, especially if you're going to use it, you must validate that it is true. You know, I've been known to make a mistake or two now and then. I have never intentionally deceived or lied to anyone. That you can take to the bank. So, with that said and done, we will proceed. You must protect yourself by setting up a financial self-defense plan that protects absolutely everything you own, earn, or may earn in the future against any legal or financial threat under any circumstances. If a lawsuit-happy lawyer or unscrupulous tax collector wants your money, you need the strongest financial protection possible. In addition, you must more than simply shelter your assets from those who want them. You must also privatize your wealth so that no one knows how much you're worth or where it is or how it's been done. In other words, shut your mouth. Shut it. Shut your mouth right now and keep it shut. You don't even have a family member that you want to trust with any of this information. So shut up and keep your mouth shut. Open your ears wide and apply what you can verify so that you can help yourself. You see, privacy has become nearly impossible. The information age makes your finances an open book. So what is the answer, ladies and gentlemen? Offshore asset protection. Offshore asset protection. Now, if you want to take a shortcut, go right to our website, harvest-trust.org. Harvest-trust.org. Click on the link on the home page that says Belize Trust Program. Belize Trust Program. You will be taken to a page where there is a personal letter from me that cuts to the quick. It does not get into detail like I'm going to do on this broadcast, but you can get a head start if you want one. It's up to you. And the strategies that I'm about to teach you, ladies and gentlemen, the strategies that I am about to teach you will give you an impenetrable financial fortress against lawsuits, creditors, bankruptcy, tax collectors, divorce settlements, probate, catastrophic illness, and dozens of other situations that could ruin your finances and your life. If you listen to this, if you verify that it's true, if you apply it as I am going to teach it, you will be absolutely 100% bulletproof. Bulletproof. An offshore, pure, individual, common law, irrevocable, discretionary trust is what all sovereign citizens need. And don't even make the mistake of thinking that a trust formed within this country is any longer safe. I don't care what anybody tells you. I don't care how successful they've been up to this date. They may have had 100% success rate up to this date, but I am telling you right now, the government is going to break those trusts and take those assets and destroy those families. Because this government is the resurrection of Hitler's dream of a social world under socialism, under the total and complete control of informants who work for the government, who are ready and willing to squeal on you no matter what you're doing, whether it's legal or illegal, doesn't matter to them. And there's rewards everywhere you turn around. Now we're going to be talking about a lot of things, but I'm going to cover first and foremost what's known as an offshore trust. I know what I'm talking about. I've been doing this for years. I have both offshore asset protection and asset protection within this country. But ladies and gentlemen, I will not keep anything in the asset protection structure that is in this country anymore, because that's how bad it's getting. If you've been paying attention to the legislation being put before Congress, you know that no matter how you conduct your business or how safe you think it is, if it's in this country, they're going to get it. The offshore trust is your first line of defense. The best way to protect your assets is to never, ever keep your wealth in the country where you live. Because, ladies and gentlemen, as I have discussed already, anything can happen, and usually does. This government is becoming increasingly despotic. The answer to this dilemma is an offshore trust. Combined with other trusts and with a business structure. But I'm going to describe the trust. An offshore trust enables you to change the title on your personal or business possessions, including stocks, bonds, real estate, bank accounts, coins, gold, vehicles, boats, etc., from yourself to the trust. You may use and enjoy the trust property during your lifetime, even though the property is in the trust name. Since assets are no longer in your name, there's no public record of personal ownership. And folks, that concludes tonight's broadcast. Don't forget to tune in tomorrow night. We're going to get very serious about your education on this broadcast. So pay close attention. Good night, folks, and God bless each and every single one of you. Annie, Pooh, and Allison, I love you. I miss you with all my heart. May God keep and protect you. You're listening to 101.1 FM Eager. 101.1 FM is owned and operated by the Cooper Family Children's Charitable Trust. And because of their benevolence, you get free radio. Best radio, as a matter of fact. Stay tuned now for all oldies most of the time. You're listening to the Hour of the Time. I'm William Cooper. Good evening, ladies and gentlemen. Welcome to part 2 in our ongoing series on asset protection. Asset is what's valuable, that you own, that is worth money, can be traded, things that people must have. And you want to protect your assets. Most people do not. Why don't they? Well, there are several reasons, folks. Number one, they're ignorant. Ignorant is not an insult. It just means that you are, or whoever it applies to, is without knowledge. Without knowledge. Without knowledge means does not have the necessary information in order to be able to do something. That's called ignorance. Once presented with the knowledge, and so they know it, many people will practice what is called denial. In other words, they don't want to know it. They'll pretend they never heard it. They will deny that it is true, even though they've never looked it up or checked, simply because they're afraid, scared to death in most instances, that if they go against what has been accepted by the majority, just like in high school, that they will either be ostracized, or persecuted, or arrested, or some terrible thing that exists within their mind. And so they do nothing. The other category is just plain stupid. People who have been given the information, they know that it's true, but, oh, it can't happen to me. Oh, gee, it can't happen in America. Oh, golly, I got plenty of time to do that, but they never do it. That class of people falls into the category of stupid. 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 Absolutely, incredibly stupid. And then there is the category of people who want to know, who want to live within the law, who want to protect their assets, and who aren't afraid to do it because they know that their posterity, their children, their grandchildren, their great-grandchildren, their great-great-grandchildren depend upon them doing the right thing in order that they might have a future. You see, that's what our founding fathers did, the ones who created this nation. They were willing to die for their posterity. What are you willing to die for? Chances are most people aren't willing to die for very much of anything, would rather be slaves, persecuted, whipped, rather than stand up and take a chance on dying. That's the herd mentality. And a lot of other things that we won't go into. So, folks, don't fall in to the category of those who are afraid. Fear will paralyze you. Fear will enslave you. Fear is a terrible, terrible thing necessary to prevent us from allowing ourselves to be eaten. And so if we use fear for what it was intended, it's not to paralyze and enslave us, but to motivate us to act, then fear can be a good thing. Okay? Pay close attention tonight. You're going to get some powerful information. I love it, folks. I love it. What category do you fall into? Well, just sit back, regardless of whatever category it is. Make sure you got your pen and paper with you, because maybe we can change it. Maybe you can get a brain. Maybe you can get a heart. And maybe you can go back home. What do you think? Maybe you can get courage. So, listen to the wizard. That's me, at least for tonight, and for the short foreseeable future. An offshore trust, ladies and gentlemen, is your first line of defense. It used to be that you could have a trust in this country, but now it has reached the point where it is too dangerous to trust your assets to remain in this country and still be safe. The United States of America is quickly becoming Hitler's dream of what he called the New Order of the World, or the Third Reich. In this instance, more correct terminology would be the Fourth Reich. Remember, the best way to protect your assets right now, today, is to never keep your wealth in the country where you live. Because, as I have discussed already, anything can happen, and usually does. And you've seen the trend in Washington, D.C. That is, if you can see, and if you can hear. The answer to this dilemma is an offshore trust coupled with a few other things that I will discuss later. An offshore trust enables you to change the title on your personal or business possessions, including stocks, bonds, real estate, bank accounts, coins, gold, vehicles, boats. In fact, anything which you may own or think that you own, from yourself to the trust. You may use and enjoy the trust property during your lifetime, even though the property is in the trust name. It does not belong to you, and you must become used to the fact that once you do this, you own absolutely nothing. Since the assets are no longer in your name, there is no public record of personal ownership. And there's a few other qualifications. For instance, if you are the settlor of the trust, the IRS is still going to say that it's your property, and they're going to try to tax you accordingly. If you are the beneficiary of the trust, the IRS is still going to try to say that it's your property, and they're going to try to tax you accordingly. And I'm going to teach you how to get around that legally, lawfully, and constitutionally, according to their own rules. Because most of you just won't play the game any other way than it is a game, folks. A terrible, terrible, destructive game. But before we explore tax strategies, asset protection, and potential high returns on investments, we must understand how to structure oneself to legally become privatized and conduct personal and business matters in a discreet and very, very safe manner. And the first thing you've got to learn is to shut your mouth. Shut it. Shut your mouth and keep it shut. In order to accomplish these things, you as an individual must become invisible. Don't be like me and get on the radio and tell the world what the truth is. You see, I'm a warrior. Most of you don't have to be until the actual fighting starts, and then you must be, because nothing will protect you then. But until then, you must become invisible. You do this by setting up what is commonly called a pure trust and signing over and placing everything you want protected into this trust, thus keeping you legally separated from those assets and liabilities. Now, you don't just sign them over to the trust, because if they are not placed into the trust in exchange for real value, in other words, what they're really worth, the IRS will say that it's a scam and that they still really belong to you because you can't sell a house for $10 or give it to somebody just by willing it away. And I'm going to talk about how you do that later, but just keep that in the back of your mind. You set up a pure trust and sign over and place everything you want protected into the trust. I'm going to tell you how you go about doing that so that it's lawfully protected later. But by doing this, you keep yourself legally separated from those assets and the liabilities which they may bring to you. Now, learning about how a pure trust works will give you a better insight on how the rich and politicians have legally and lawfully manipulated their careers and fortunes for decades. This same trust will allow you to do exactly the same thing that they have been doing for centuries. So what exactly is a pure trust? I know that many of you are sitting there wondering that what is a pure trust? What the hell is he talking about? A pure trust, ladies and gentlemen, is one. It's a trust in which three parties of the trust, the settlor, the trustee, and the beneficiary, are, in fact, three separate entities. And in fact, could be more than three entities. But these three basic entities, as we're going to discuss, as settlor, trustee, and beneficiary, become one through the trust, thus creating an entity in itself. It's based on what has always been called the common law. And if you think the common law does not apply, if you've heard some federal parrot tell you that, I suggest you read the Constitution for the United States of America, where it clearly talks about common law. This is a pure contractual trust called a declaration of trust. It is recognized by most governments and governmental agencies throughout the entire world. It is a part of the law. Now, one person cannot totally control and hold possessions or assets of the trust. This, in fact, would be a conflict of interest and can destroy the credibility of the trust. And so you must listen to me very carefully. The most important thing to remember is to keep with the form of a pure trust. But let's go a little bit further than that. Let's not just keep with the form of a pure trust. Let's make it a pure trust. You must have the three separate entities holding the three different positions: the settlor, the trustee, and the beneficiary. What makes this pure trust such a powerful instrument? Well, as I have discussed earlier, the reason this trust is so powerful is that it is written under common law as a pure trust, under the right guaranteed by the Constitution to contract. There is no other structure that exists which is more powerful and more flexible for personal or business purposes written under common law. Now, what's the difference between a pure trust and a living trust, which I know most of you have heard about? You hear about living trusts on television, on radio. You may have someone who's related to you who talks about their own living trust. Well, here's the difference. A living trust can be operated by the same person who benefits from the trust structure. In a pure trust, and here's the difference, in a pure trust, you cannot do that. There has to be a minimum of three entities: the settlor and the first trustee for the benefit of the beneficiary. If you were found to actually own the assets you were controlling, anyone could pierce that trust. It could be broken. In fact, if they find that you control the assets even though you don't own them, the trust can be broken. So someone has to make a gift to you of the initial assets in order to establish the pure trust. And I'm telling you, and I'll talk about it later, it's better to sell the assets into the trust for real worth. It makes the trust bulletproof. And I bet you've never heard that from anyone before. But listen to me, and I'll tell you how to do it. After that, the way the trust is written, anyone can donate or sell assets to the trust. And it's always better to sell for real value than to donate. And this is how you can transfer your possessions. So anyone who has set up a living trust with the intention of total protection of assets is going to be very surprised to find out they are at extreme risk and need to immediately set up a pure trust to achieve those goals. In other words, a living trust isn't worth the paper that it's written on. I don't care what your lawyer says. I go by what the courts say. The courts break living trusts every single day. They're not so successful with pure trusts unless you violate the provisions under which they must be established and administered. Is a trust usable in any state or country? In other words, could you establish a trust in a foreign country, and is it lawful? Is it usable? Will it help you? Well, the answer is yes. Not only yes, but hell yes. You can place what is called a situs in any state or country that recognizes common law. The situs is the legal address established under the trust jurisdiction. This becomes the legal address and controls how the trust is treated. It's exactly the same as when you sign a contract with a company and they tell you in the fine print how their state's law takes precedence over any legal matter that may develop. And if you sign it, you're agreeing to that. They're simply stating, folks, the jurisdiction properties of the contract. Remember, a trust is also a contract. So, the best thing that you can possibly do, right off the bat, is pick a tax-free state for your situs. If you are a citizen of the United States of America, or if you are a citizen of one of the several states of the United States of America, and you decide to set up a trust inside the United States of America or one of the several union states, your trust may be liable for state income tax. In the United States of America, some states do not have state income tax. So if you place your situs in a state such as Nevada, Texas, or Florida that does not have income tax, you may be able to legally avoid those types of taxes. And there's really no maybe about it. You will absolutely be able to avoid those types of taxes for the trust which resides in that particular jurisdiction. Now, this same concept holds true for setting up your situs offshore in a tax-free haven. For instance, and I'm going to talk about this a lot because it's the safest place today. Belize is one of those tax-free havens, and people from the United States of America, as well as other parts of the world, set up trusts in that country by the thousands every single month. You don't have to live there. In fact, if you're the settlor or the beneficiary of the trust, you cannot live there. You're forbidden to live there by law. Now, you know how the rich and famous delayed and avoided their government taxes? They set up international business corporations, and this is the other part of this arrangement. And there's one other thing that we'll talk about before I'm finished. They set up international business corporations and offshore trusts and used those entities to invest back into their country. Now remember, a trust is an entity unto itself, and when set up offshore becomes a non-resident alien of the country it wants to do business in and is exempt from those taxes. So what is an exempt trust? It simply means, ladies and gentlemen, that you are not taxed by Belize on the income that the trust earns. Now let me say that again. The trust resides in Belize, which means that you are not taxed by Belize on the income that the trust earns, because in Belize they do not tax trusts. It's a tax haven. Belize attracts the business of the wealthy people of the world by not taxing them. And so they bring their money to Belize. The trust is also not taxed on capital gains, nor is any duty charged on any estate through the trust. Wow, can you imagine that? How many people die every day, whose estate evaporates in probate, when the lawyers and the children and all of these people fight over the assets. That can't happen with a trust. Now, what determines an exempt trust? The settlor, protector, and beneficiary may not be residents of Belize any portion of any calendar year in order to remain an exempt trust. Now, that does not prohibit you from visiting Belize on a vacation, but you must be careful that you do not stay long enough to qualify for resident status. And really, to have a trust domiciled in the country of Belize, you don't ever have to visit Belize if you never want to visit that country anyway. Now, there are several types of trust. And we're going to talk right now about an asset management trust. An asset management trust is designed for personal affairs and is not for business purposes. An asset management trust is designed for personal affairs and is not for business purposes. Although the trust is a separate entity and can own assets on its own, this document specifically prohibits any new business startup by the trust after the date of the trust's inception. It is allowed to operate an existing business that has been transferred to the trust, but only to eventually sell it or close it down and distribute the assets to the beneficiaries at a later date. That later date could be 120 years from now. So don't get confused about all this. Don't think that because that's what has to happen, that it must happen tomorrow. It just must happen eventually within the lifetime of the trust. The purpose of this clause is to prove to any bank that it is strictly a management trust. This type of trust is typically used to hide personal assets such as stocks, bonds, real estate, cars, trucks, boats, yachts, retirement homes, cash, etc. But remember, ladies and gentlemen, when they are transferred to the trust, they are no longer personal assets. You do not own them anymore. The trust does. Now, you'll find that this is one of the slickest of all trusts. It has numerous loophole clauses that allow you to do just about anything you need to do whenever the time is right. But if that's not for business, how can you protect your business assets from financial disaster? Well, you set up a trust immediately. If you're operating without the protection of a trust, you are vulnerable to every type of lawsuit available in your country, wherever you live, whichever country it happens to be. One stupid, frivolous lawsuit could wipe out years of work in a matter of weeks. If you do by not having a trust. So don't delay too long without doing something. Even if you don't do a trust, you got to do something. If you don't get protection, at least get protection in some manner. The best way is an offshore trust. Now that sounds funny. If you don't get protection in some manner. But it's not. Think about it. There are many ways without getting protection from some other jurisdiction or venue, or without getting protection from a contract, that you can go about protecting your person, your personal assets, and your business. But this is not the forum for those things. We're specifically talking about trusts, IBCs, and later we're going to talk about a foundation. What is a preferred asset holding trust? Ladies and gentlemen, it's commonly called a business trust, like Harvest Trust. It's a separate entity and it can own and run a business on its own. As with any entity, it can buy and sell property and services. It can be sued, and it can. As with any entity, it can buy and sell property and services. It can be sued, and it can sue others. It can open a bank account and take out loans. It can make a profit, lose money, and it can also go bankrupt. Now, since it is a separate entity unto itself, the managers and trustees of the trust are not personally liable for the misdeeds of the trust. Now, there are exceptions, such as if the manager or trustees have personally guaranteed notes, or break the law where the trust is doing business, or betray the bylaws of the trust. And you must take great pains, ladies and gentlemen, to make sure that none of those things ever happen. Now, one of the best things that you have that you can use in your favor is called layering. Now, get ready and pay very close attention, because this is what you have been waiting for. Using the example of the asset management trust, that's the personal trust, and the preferred asset holding trust, that's a business trust, that the rich and the politicians have been using, what is commonly called layering is used to hide their business interests and their money from the public and the government. And what you're about to learn will make and save you thousands of dollars in the years to come. Now, I'm talking in language that you can personally understand, but remember, when I say that it's used to hide someone's business interests and someone's money from the public, the moment that these things are placed in the trust, it is no longer their business interest and it is no longer their money. I know some of you are sitting there scratching your head. Why would I give all my business and my money and my property and my real estate and everything to somebody else? Well, in order for it to be a pure trust, you must. You have to. There are ways in which you can make sure that it's used in the manner that you wish it to be used, and that it's used for the benefit of those whom you wish it to be used for the benefit of. Now, this is commonly called layering. It's commonly called layering. What you're about to learn will make and save you thousands and thousands, maybe even millions of dollars in the years to come if you pay attention. And if you can overcome your fear and take the proper steps to make it work. Your objectives and your total assets are what determine how you need to structure and layer the trusts. And it's not just the trust that you're going to layer these trusts in combination with international business corporations which you will form. You should start with asset management trusts. You should place your high liability assets in one trust, such as cars, trucks, motorhomes, boats. These assets have a tendency to run over people, literally. Blood-sucking lawyers love to do asset searches to find out how much they can make for themselves and their clients by suing you. I know some people who have several trusts that control these assets, and where they may have several of these extreme liability assets, there's only one placed in each trust rather than all of them in one trust. If the car is under a trust name and the trust is not recorded, as I have already told you not to do, you do not ever need to record a trust. It's difficult to find what the trust is worth. And if by chance the trust is sued, they can only take what is in that particular trust and nothing else. And that's why the people that I told you I know about may have 6 different trusts just for automobiles, boats, RVs, and things of that nature. And in each trust, there's only one of those placed in a trust at a time. Because remember, if the trust is sued, they can take whatever is in that particular trust. Passive assets, such as checking accounts, stocks, bonds, cash, reserves, etc., should be in another trust. Each piece of real estate should be in a separate trust. For instance, if you own 3 homes, each home should be in its own trust. Real estate has some liability in that someone can fall or be hurt. And keeping each piece of real estate in a separate trust allows a lawyer to only take what that particular trust is worth, or a portion of it. Now here's a valuable tip, ladies and gentlemen. If your real estate has equity, attach a lien, either a first or second, on the real estate by creating an additional trust. It's very easy to do. In the event that the beneficiary becomes insolvent, there is what's called a spendthrift clause. In a spendthrift trust, in a spendthrift trust, or what's called a protective trust, in the event that the beneficiary becomes insolvent or any part of his property becomes liable to seizure or sequestration, which means separated from the trust, for the benefit of his creditors, the trust has the right to minimize the beneficiary's interest in trust funds to a degree necessary to prevent such action from hindering the smooth operation of the trust. It's in the best interest of the assets. This clause, this type of trust, is designed to protect the beneficiary against his own incompetence or inability to properly handle money or property. And that brings up another question that I'm sure you're all asking by now. Who owns all this stuff? Who owns the asset protection trusts? Who owns the property that's in the trust? And the answer, very simply and very clearly, is no one but the trust. The trust owns it. There are beneficiaries, however, typically your children, can be anybody else, but typically your children should be the beneficiaries. And if you don't have children, any relative you can work with directly to support the credibility of the trust. Now, if you don't know who to place as beneficiary, use the same person you would name as an heir in your will, because the purpose is the same. You're preserving your assets for your posterity, whoever that may happen to be. Now here, ladies and gentlemen, is where things can become very interesting. Any legal entity, such as a corporation, charitable organization, limited partnership, or even another trust, can hold the position of either the settlor, the trustee, or the beneficiary. Now remember, earlier I told you you're going to operate these and structure them in conjunction with international business corporations. It's called layering. This tactic is used when a person wishes to create multiple layers of protection by establishing more than one trust. And, in conjunction, you should establish more than one international business corporation. If you keep with this concept, the more multiple layered trusts you can establish, the more protection you have. Establish one or more business trusts, of which it can either be the settlor, trustee, or beneficiary of one or all of the asset management trusts, holding the vehicle, the cash, the stocks, the bonds, the real estate, your clothing, whatever you wish to put in there. Of course, the business trust can run and control your business, and additional business trusts can be established to own and control assets for the business or other businesses which you may be involved in running. Where does a trust get its name? Well, you're free to choose any name you wish, within limitations. Most people use the name that partially describes what they are doing, or they simply use a name of a city or location and add the extension holding trust or management trust. You may not, listen to me carefully, you may not, however, use one that sounds like a banking or lending institution. You cannot do that. Common knowledge also tells you to stay away from names that could be confused with those that are already protected by a trademark, patent, or copyright. For instance, you would not want to call your trust Coca-Cola Trust. Does a trust have to be registered? Absolutely not. Nowhere. In fact, you should avoid this procedure at all costs. A trust can be legally run without being registered. No one will know who runs the trust if you do not register it. No one will know what's in it unless they take great pains and are really slick. And, of course, if you have a condition commonly known as flapjaw. Flapjaw, you know. You know people like that, don't you? Kids can't wait to tell you every single little detail of their personal life, bank account, work, how much they got paid yesterday, their sex life, their love life, and just about everything else that you can think of. It's called flapjaw. It's a terminal illness that causes lots and lots of trouble. An offshore trust, ladies and gentlemen, has all the advantages of a corporation and absolutely none of the disadvantages, and it can operate anywhere in the world as lawful business. Corporations are taxed on their net profit prior to distribution of dividends. Shareholders are taxed on dividends received. Offshore trusts are only taxed on the profits that are not distributed to the beneficiaries. If all profits are distributed, the trust has no tax liability. So how does the offshore trust compare with the domestic trust? Listen to me carefully. An offshore trust is similar to a domestic trust, except it has several features that are much better. And here are the main differences. Number one, domestic trusts remain vulnerable to creditors. The laws of the country determine what enforcement measures creditors may take. Unlike domestic laws, the laws in offshore havens are always, in every single instance, in favor of the trust, never the creditor. Number two, even if a domestic court compels the settlor or beneficiary to take his or her assets out of the trustee must, by the law of the country where the trust resides, refuse this request, and the laws of that country will enforce his refusal. Number three, the law also compels or authorizes the trustee to relocate the trust to another country if the trust becomes endangered in its present location. Number four, the trustee can alter the rights of any beneficiary under creditor attack to eliminate claims against the trust by that creditor. And number five, a domestic trust in this country today is in extreme danger of being unlawfully broken, dissolved, and having its assets seized by the unconstitutional, outlaw, jackbooted Nazi thugs of the Internal Revenue Service. And you all know it. The law in this country, it appears to me, no longer have any force of law at all for us, the citizens of the several states, whereas it can be used to full force against us, and they can even make up the law as they go along. They do it every day. Offshore A trust has no periodic reporting or accounting requirement to any agency whatsoever. It is a lawful person and has the same rights as an individual. It is a lawful contract under common law, and it is not regulated by any statute. So if a trust is so good, ladies and gentlemen, why is it that not everyone has one or uses the trust structure? Well, it's very simple. Most people are ignorant. In fact, if you were to take a poll of all of the people that you meet every day, you would find that most people have never even heard of it, much less know anything about it. And then there is the fear of deviation from what is normally practiced or acceptable in your community. You see, not everyone understands or can operate a trust. Keep in mind, folks, it does take a degree of finesse and business savvy to understand and remain under the protection of a trust. The average person will not want to devote the time or patience or work to grasp the knowledge and understanding they need in order to work through a trust. Add layering and international business corporations, and the average couch potato will run away from it, because it requires some study and some work. And these things, the average American spends a great deal of time avoiding every single day. The average person just does not want to devote the time or patience to grasp the knowledge and understanding they need in order to work through a trust. This is where we can help you. We understand the average person may not take the initiative to establish a trust on their own. Obviously, most of you listening to this broadcast are not the average person. Since you've been listening to this broadcast for, well, in some cases, many years. All you have to do is make up your mind, and then if you make up your mind, trust in God and just do it. You've heard me say that before. It's my motto. I determine what is the right thing to do, I trust in God, and I do it. I take great pains to establish the foundation of knowledge, understanding, and wisdom, and then I work very hard to make it work. You have to do the same thing. Most people don't have anything offshore. They don't have trusts. They don't have international business corporations. They don't do business offshore. In fact, most people never even take a vacation offshore. Offshore means outside the continental limits of the country. They have what's called an insular mindset. You see, they believe that everything they could ever want is available right in their own backyard. In effect, they isolate themselves from other countries. And very few people, as little as 5% in some countries, even have passports. I would venture that most of the people listening to this broadcast do not have a passport, have never had a passport, have no plans to ever get a passport. Not only do most people physically stay within their own borders, but their idea of traveling to a foreign country is a trip, usually, if we're talking about Americans, to Canada or Tijuana. For example, the Congress and the Internal Revenue Service know they have a captive market of taxpayers because Not only do most Americans not think in terms of investing outside the United States, but they are even more horrified at the thought of ever having to live outside of the United States. Their concept of how people live in other countries is colored. Congress could pass legislation that would double the present tax in this country. Whether it's legal and lawful or not, doesn't matter. Most of you keep right on filing and paying anyway, even though most of the people listening to this broadcast know that there is no law that requires it of any citizen living inside the territorial boundaries of any of the several states of the Union who are not employees of the government. You do it because you're afraid. So even if Congress doubled the income tax tomorrow, you would continue to file and pay. They know that, I know that, and you know that, and most Americans would still not even consider leaving. They would just stay, and they would continue to pay, like the sheeple that they are. And that includes most of you. Now, although it's not necessary to leave the United States of America at this particular time, might be a good idea to do that, Americans had better wake up to the fact that their opportunities of retaining their wealth are decreasing rapidly. In fact, your chances of ever gaining and keeping wealth in this country into the future as they cement their new socialist world order, and remember, it is the United States from which all of this is coming from, is very slim. While at the same time are increasing rapidly throughout many areas outside of the United States of America. You would be amazed to hear what people who live in other countries think about the United States of America and about us, the citizens who live here. You would be absolutely amazed. And you wouldn't like it. I'll tell you that right now. The consensus is that we're the biggest single group of ignorant people who live upon the face of this earth. And it's a correct consensus of opinion. The days, ladies and gentlemen, of having everything tied up in a neat little package, safe and secure, what we used to call the American dream, is no longer a reality. You can't have it. And Uncle Sam has set about making sure that you can't have it. Most of you think offshore trusts are just for the rich. Although the rich have had trusts for years, that is not the case. Never has been, as a matter of fact. Now that offshore trusts can be started with only a small investment, they are affordable and readily available to the average individual and family, no matter who you are or how much you make, no matter how great or how small your little pile of possessions may be. Many individuals and families who have an offshore trust are not necessarily wealthy, but they are concerned about protecting the assets they have worked hard for. Others use a trust for estate, divorce planning, to run businesses, and they're very successful. But the government, ladies and gentlemen, listen to me, the government does not want you to know about the benefits of any kind of a trust, whether it's in this country or offshore. And they go to extreme length to go after and break the trusts that are located in this country. Most of the time, they are successful. They have never been successful at going after and breaking trusts which are offshore in the countries that protect trusts, such as Belize, which right now is the very best place in the world to have a trust. You see, the primary goal of the government, or at least they think it is to appropriate every single dollar they can get their hands on. The fact that they cannot get their hands on money secured in an offshore trust, even if taxes are owed by the taxpayer, is very troublesome to them. They don't like that at all. And if they could force every country to cooperate with them, they would. But fortunately, ladies and gentlemen, they cannot. They can only pass laws that compel the taxpayer to voluntarily disclose the existence of an offshore trust and pay taxes where applicable. But they cannot get their hands on the trust's assets under any circumstances. And if you set the trust up properly, they cannot even compel you to disclose the existence of the trust. For instance, if you are not the settlor, if you are not the protector, if you are not the trustee, and if you are not the beneficiary, there are no laws which can compel you to say even one word about a trust. Period. The fact that the government does not and cannot control the laws of other countries is why more and more citizens are seeking asset protection offshore. And don't worry, I'm going to teach you how to set it up so that nobody can make you even say one word about it. And that's it for tonight, folks. Don't forget to tune in tomorrow night, and we will do some more of this stuff. In the meantime, take the advice that you're going to hear on this Shuffle Off to Buffalo song. Good night. God bless you all. Annie, Pooh, and Allison, good night. I love you with all my heart and soul. I miss you. I wish you were here or I were there, wherever you're at. May God keep and protect you safe in His loving hands. You are listening to the Hour of the Time. I'm William Cooper. Ladies and gentlemen, welcome to part 3 in a continuing series on protecting your assets. What you have to do in order to keep someone, anyone, from taking away everything that you have worked for all of your life. And literally, it can happen overnight. It will happen to somebody listening to this broadcast tonight. Now think about that. It will absolutely, without any doubt, happen to someone listening to this broadcast tonight. Maybe more than one or two people. With the kind of clientele that this broadcast attracts, people who value freedom, privacy, people who are patriots, which today is a politically incorrect mode of thinking. We are the targets of the New World Order, you and I. That's a fact. Whether you want to know about it or not, it is a fact. Now, folks, the only reason that you would want to do this is if you care more about those that you love, or at least as much about those that you love as you do yourself. If you're a selfish person and you don't care about leaving anything for anybody and you don't see the need to take care of your children or your grandchildren or your great-grandchildren, this is not the broadcast to be listening to, because I'm not talking to you. You must have the capacity to love. You must love others deeply. You must even be able to project that love onto those who are not yet even born. And you must be the kind of person who is preparing their world for them now, before they even are a speck in their parents' eye, maybe before their parents even meet or ever are married. And for what we call our posterity, the chain is endless so far into the future that we can only imagine who and what they might be. But some of us have that capacity. I have that capacity. I know many people personally who have that capacity because those are the kinds of people that I tend to gravitate to, that I care about the most. People who love freedom, who love their families, who love their children and their grandchildren and their great-grandchildren and their great-great-grandchildren yet unborn, and what they call their posterity, what we call our posterity, whom we love, though they may not even exist in this world at this time. For some, that's a very hard concept to grasp. In fact, I know people who could not ever understand it in a million years. And with me, and with many of those that I love, it spreads beyond our immediate family, to our friends, to those who are loyal to us, to those who believe as we believe, to those who would give their lives so that we may all live free. Because if they're willing to give their life so that we, listen to what I said, so that we may live free, then they are willing to make the ultimate sacrifice for me, and I in turn must love them. I must love them. I could no more prevent myself from loving them than I could prevent the sun from rising once more tomorrow morning. I know this is very difficult for many of you to understand. But if you understand it, you are the right person to be listening to this broadcast and to be absorbing the information that I am giving you in this series. The government, ladies and gentlemen, does not want you to know about the benefits of trusts, no matter where they're located, but especially offshore trusts. Because if they ever go after you, they might get you if you're in this country, but they'll never get not one single one of your assets, not $1, if they're located offshore. They will be safe for your posterity. The primary goal of the government is to appropriate every single penny they can from every single person in this country. That's the goal they've set for themselves. They want a socialist world, which means they must eliminate the middle class, and they have set about to do that, at least in this country. Oh, yes, they certainly have. And if they could force every single country on this earth to cooperate, they would. But fortunately, they can't do that. They can only pass laws that compel the taxpayer, if you believe that you're a taxpayer, to voluntarily disclose the existence of an offshore trust and pay taxes where applicable, but they cannot get their hands on the trust's assets under any circumstances. And if you're not the settlor, the trustee, or the beneficiary, or the protector of the trust, they can't make you pay any income tax on anything that the trust does, has, earns, accumulates, dispenses, disperses, profits, doesn't matter what it is. You're not liable, even under their convoluted criminal outlaw assertion of the color of law. The fact that the government does not and cannot control the laws of other countries is why more and more citizens are seeking asset protection offshore. Remember during the O.J. Simpson trial and the following civil lawsuit, there was this big to-do about where is all his money, all his millions of dollars they earned over the years. They couldn't find it. I think one of his relatives was on television being interviewed, and she said, well, it's because it's all offshore. They never will find it. They'll never put their fingers on it, and they'll never hurt O.J. Simpson financially. And it's the truth. Attorneys do not want you to know about the benefits of an offshore trust. Do you know why? Because we live in the most litigious society in the world, ladies and gentlemen. In the United States, there are 2.67 lawyers for every 1,000 people. In Japan, there's one lawyer per 100,000 people. In fact, 2/3 of the world's attorneys live and practice in the United States, yet we have only 6% of the entire world's population. Now listen to me very carefully. We have 2/3 of the entire world's attorneys, yet we have only 6% of the entire world's population. Doesn't that tell you something about the wrong turn that this nation has taken? Your chances, ladies and gentlemen, and you better listen to me carefully, your chances, your personal chances, everyone listening to me right now, your personal chances of being involved in a lawsuit in any given year are 1 in 4. 1 in 4. We are literally swamped with greed and greedy individuals and money-hungry lawyers who must manufacture, and yes, I said that correctly, manufacture lawsuits to keep busy stuffing their pockets. Unfortunately, many of the lawsuits that are filed are frivolous and border on extortion. Did you also know that the average successful litigant collects less than 50% of a settlement? The rest goes for attorney's fees. Did you know that no matter how little a lawyer might work on your behalf, if you were to secure a $2 million judgment, 1/2 of that, 50%, $1 million would go into the lawyer's pocket, although he didn't deserve it at all? And it would be that way because you, in your state of greed, would happily sign a contract allowing him to do that. Attorney's fees, court costs, collection fees. By the time you get what's coming to you, there isn't much left, ladies and gentlemen. Any wonder why attorneys don't tell you about offshore trusts and how to avoid lawsuits? Most citizens perceive offshore finance as too complicated, just like they perceive the law. But just like the law, it's very simple, very easy to understand, cut and dried, as a matter of fact. Even if they are interested in investigating the possibility, they do not know where to begin to get reliable information. More importantly, they do not have access to anyone who can actually set up a legal, non-discretionary offshore trust as well as an offshore bank account. And as you will soon see, this is no longer an obstacle. It's not an obstacle at all. Now, anyone can diversify his or her, and I'm talking about you in particular, you listening to this broadcast, your assets abroad in countries that have higher interest rates with absolute, complete safety, tax-free. Tax-free. The average citizen, you see, because of the high school clique mentality, believes that if it requires them to do something that their neighbors and their friends and their relatives are not doing, that there's something somehow wrong with it. They believe that offshore trusts, international business corporations, or offshore bank accounts must be illegal and are only for money laundering crooks, tax evaders, and those with illegal motives. Couldn't possibly be for the stupid, ignorant sheeple like them, could it? Well, unless they cure that status that they are in, it's really not. Ignorance that abounds and surrounds offshore finance results largely from misinformation and listen to me closely, non-education. However, the fact remains that every single Fortune 500 company has offshore financial interests, as do the top 10 banks in the United States. All foundations, most charitable organizations, and almost all of the rich people in the world. In addition, tens of thousands of Americans now have over $3 trillion, that's trillion, not billion dollars, secured in offshore accounts. Are you listening to me carefully? I hope you are. Now, rest assured, an offshore trust is 100% legal. A trust is legal anywhere, provided it's set up properly and provided it's administered properly according to the law. You see, I would never advise you to do anything illegal. Never, ever in a million years. Not only would I not advise you to do anything illegal, I would never advise you to do anything that's unlawful either. Remember, lawful always takes precedence over legal. Now, the government does not want your money offshore. And if you think trusts are illegal, look in the United States Code, do a search for trusts, and you'll see that the United States government administers many, many, many trusts. You'll also hear them talk about the Social Security Trust Fund, although there is no such thing. There are many other trusts that are, in fact, in effect. And particular departments of the United States government act as trustees for those trusts in the person of whoever is the department head, such as the Secretary of the Treasury. So if you don't think trusts are legal, why is the United States government engaging in the formation and administering of trusts as trustees? It goes much farther than that. One of these nights we're going to get into it, how they create a trust in your name, making you think that you're the trust, and then making you subject to laws that you would not and are not subject to as the non-trust living human that you really are. Remember, this is the age of deception. And you better be pretty sharp not to be deceived. The government does not want your money offshore. They prefer that you keep it at a local bank where they can keep an eye on it, or take it if they want it, and know exactly how much you earn and what you do with it and where it goes. However, it is perfectly legal to take your money out of the country free of taxes. Absolutely perfectly legal and lawful. Offshore investments are not only legal, but they're smart. And if you're not a part of it, then you're not acting with due diligence in protecting that which you have spent your life earning. You're not very smart, in other words. Assuming you understand that an offshore trust is legal, ethical, and highly effective method to preserving your assets, the next thing that comes to mind is, how safe is my money if I send it offshore? Again, all skepticism concerning offshore banking is based on ignorance and fear. It's really based on Hollywood movies that portray people who live in foreign countries as third world revolutionaries ready to rise up and destroy everything, bringing about a state of chaos, death, and poverty. And that's exactly where you get it, from Hollywood. And in most of the nations of the world, it is not only a remote possibility, it will never happen. Now, I'm going to tell you right now that your money is far safer offshore than in the United States. Now listen to me. I'm going to tell you that again, and you'd better listen to me very carefully. I am telling you right now that your money is far safer offshore than in the United States. And I'm going to discuss this in detail throughout this series. As a point of fact, Offshore banks are safer than United States banks, and here's why. You see, offshore banks must maintain a higher ratio of liquidity. In other words, in the United States, we live in a debt-based society where money cannot be placed into circulation until someone borrows it, which means it does not exist, never existed. It's a figment of the imagination. It is a bookkeeping entry. This bookkeeping entry appears when somebody walks into a bank and borrows $10,000. The bank does not give this person $10,000 in cash. The bank on that given day probably doesn't even have $10,000 in cash in its vault. The bank makes a bookkeeping entry creating an asset based upon the debt of the person borrowing the money. The bank does not give this person $10,000 in cash. The bank cuts a check for $10,000 and hands it to the person who borrowed the money, or transfers the bookkeeping entry to the person's account in that bank, making credit available for him to write checks against this non-existent $10,000. That's what they call a debt-based economy. And if you don't believe me, you start studying how this economy works, and you'll see that what I've just told you is the absolute truth. In foreign countries, that is not the way that it happens. Most foreign countries are not debt-based economies. They cannot have a bank that has empty vaults and millions of dollars loaned out and deposits for millions of dollars on their books. They must have the money. They must have the cash. They must be able to prove that they have it, or they will not long exist. This is about the only nation in the world where you can start a bank with nothing, loan money, take deposits, invest those deposits, and make money, and nobody seems to care whether you have any money to cover what you're doing or not. Now that's a stretch, because most of you could never go out and start a bank. You must have some proof of financial performance. But basically, what I just told you is absolutely the truth. And many of you have already discovered that. Offshore banks must maintain a higher ratio of liquidity. In other words, if somebody comes in that bank and says, I want my money right now, they've got to be able to give it to them. Now, if you think this is a stretch of the imagination, go down to your bank tomorrow and tell them you want to withdraw $20,000 in cash right now and see what they say. They will put you off for 3 days because they don't have it. They can't give it to you. If they did give it to you, they would have to close the doors and stop doing business because they could not give anybody else any cash. Everything in this country is done by electronic transfer through checks, credit cards, debit cards, loans, bookkeeping entries, electronic transfers, writing checks. Do you understand what I mean? The cash simply does not exist. That's why the Federal Reserve, in their fear of what might happen with the scare of Y2K, caused 50 billion with a B, that's billion, $50 billion in Federal Reserve notes to be presented and divided up amongst the Federal Reserve banks in case there's a run on the banks because of the fear of Y2K. Now, You have no idea what's going to happen if they actually have to pay out that $50 billion. You see, because that will cause the value of the dollar to plummet. $50 billion put into circulation all at one time will cause the greatest spate of inflation that's ever incurred in this country, ever in its history. The value of the dollar will plummet. Prices will go up everywhere, sky high. And you're going to get poor real quick. Inflation is not caused by raising the price of oil. Inflation is caused by pumping more worthless money in the form of Federal Reserve notes, paper with no value, or credit or debt into the economy in a short period of time. In other words, it makes large amounts of money available to more people who normally would not have the ability to get that money. When there's large amounts of money available, credit becomes available for almost anyone and everyone anytime they want it in just about any amount. And so because everyone knows that everyone has more money, they raise prices on everything. Your rent goes up. The price of purchasing a house goes up. The price of oil goes up. The price of paper goes up. The price of an automobile goes up. The price of gasoline goes up. The price of Snickers candy bars goes up. Why? Because everybody all of a sudden has a lot of money and they can pay for it. But it never lasts very long. Because the Fed has a way of, over a period of time, taking the money back out of circulation and burning it. And so all of a sudden, the prices are higher, the money is less available, your salary did not go up, and you can't make ends meet anymore. In other words, offshore banks are financially stronger and better managed. Unlike their United States counterparts, offshore directors are directly liable to the depositors. Not one single person sitting on a board of directors in any bank in the United States is liable for anything. If they were, they'd stop doing a lot of the things that they do. If Alan Greenspan were liable for your loss of the ability to purchase things with a dollar that all of a sudden was inflated beyond your ability to keep up with it, for your loss of the ability to purchase things with a dollar that all of a sudden was inflated beyond your ability to keep up with it, he wouldn't allow that dollar to become inflated. Or the opposite, deflated. If he could be found liable for your damages because of it. Offshore banks operate efficiently and economically because they're basically structured accounting systems. This means that they have low overhead and no expensive buildings, ongoing advertising budgets, or high wages. And this, ladies and gentlemen, enables them to pay higher returns on their depositors, or to their depositors, I should say. They can pay higher returns to their depositors. Savings accounts earn higher interest offshore. Investments of every kind earn higher interest offshore. Offshore banks, ladies and gentlemen, operate the same way as banks do in the United States, and in fact use the same channels and clearing houses. But they do it in a responsible, in a judicial. You see, you have to know something else about any subject that you are going to talk about or think about or become involved in than what you see in Hollywood movies. Hollywood is fantasy. But yet, Hollywood makes up the total impression of almost everything in most American lives, whether it be in this country or offshore. Now let's talk about an offshore trust. Let's get a little deeper into this. An offshore trust involves 4 parties. The settlor. Now we talked about the settlor before, but we didn't really go into any kind of depth. The settlor can be a man, or a woman, or a trust, or a corporation, or a foundation, or it can be several people operating as a group. It can be a partnership. The settlor creates and funds the trust. The settlor appoints the trustees and names the beneficiaries. Excuse me. The settlor must own the property he or she transfers to the trust and have full legal authority to transfer the assets. Any person who has, under the law of Belize, and we're talking about Belize Trust because it's the safest place in the world to form an offshore trust today. Any person who has, under the law of Belize, the capacity to own and transfer property may be the settlor of the trust. The settlor may also be the trustee, beneficiary, or protector, although this is not recommended. Remember what I told you. If you are the settlor, the protector, the beneficiary, or the trustee of a trust, you are the target for the IRS to break the trust or to come after you individually if they can't touch the assets of the trust, which they cannot do offshore, can't break it, can't touch anything in it. They can come after you for not filing and paying the income tax under their convoluted criminal interpretation of the unconstitutional administration of the Internal Revenues laws and throw you in jail. Now, your assets will be protected for the beneficiaries, unless that was you. But you can change that even from prison. Your assets they will not touch, and they will be safe for whoever the assets are meant to benefit. So it's not recommended that you be any of these things. The settlor cannot be a resident of Belize in order to comply with the exempt ruling for the trust. The settlor's position is this. He or she is the person who initially wants to settle the trust. He or she contracts with the trustee to accept the initial contribution of money into the trust in exchange for the trust certificate units. It's like shares of stock. Whoever holds the trust certificate units as the beneficiary or as the settlor until the beneficiaries are named is the recipient of the benefit of the assets of the trust, either now or at some point in the future. 1 month, 1 year, or it could be every year or every week or every 2 years or 25 years from now. You could specify that the beneficiaries, your children, will not receive 1 single penny until they reach a certain age, when a disbursement would be made. You can specify that they receive an allowance every month for the lifetime of the trust. There are many different ways that this can be done. You're not restricted to anything. Remember, this is done under contract. You have a right to contract anything that you wish. Now, once the settlor has the trust certificate units, he or she then issues a letter of wishes for the distribution of the trust certificate units to the beneficiary or beneficiaries. And the beneficiaries can be anyone. They can be children. They can be old folks. It can be a foundation. It can be a corporation. It can be another trust. It can be yourself. It can be a family. In fact, every member of the family, including those yet unborn. Are you beginning to get the picture? After that, the settlor steps out of the picture and no longer has any active management duties or ties to the trust funds. Under the law of Belize, any person who has the capacity to own and transfer property may be the trustee of the trust. The trustee may also be a corporate or artificial entity. You see, the trustee can be any of these things also. The trustee can be you, can be your mother. The trustee, however, cannot be a child. It must be someone who legally has the capacity to own and transfer property, to sign contracts and be bound by those contracts, to be responsible for their signature on those contracts. The trustee may be a corporation. It can be a foundation. It can be a partnership. It can be a man or a woman. It can be anything that you can imagine. It can be an organization. Anything that fulfills the requirement that they have the capacity to own and transfer property, to make contracts, to be responsible for the decisions made on behalf of the trust. The trustee may also be a corporate or artificial entity. The trustee may also be the settlor, beneficiary, or protector. But you really don't want to be any of those things. And I'm going to explain to you why later. I'm going to tell you how to do it. The trust document specifically states that the trustee does not have to be a resident of Belize. Now, once the trust is formed, the trustee has the daily duty of maintaining the minutes concerning any activity of the trust. If the trust decides to purchase or sell some of its assets, these must be recorded in the minutes of the trust. If the trustee should so choose, he or she may decide to delegate some of the day-to-day operations of maintaining the trust to another person. This other person may be called the managing director or the general trust manager. If no other person is appointed, the trustee retains those duties. Now, the settlor can make provision that some other person, including the settlor, could be appointed to the position of the managing director or the general trust manager. It can be a part of the contract establishing the trust. The trustee is appointed by the settlor to manage the trust for the benefit of the beneficiaries. Selecting the right trustee, ladies and gentlemen, is extremely important because the trustee completely controls the trust. As a settlor, you should never, ever be the trustee if you want creditor protection and if you want to be safe from the infernal revenue service, the Nazi jackbooted thugs. You must appoint one foreign trustee. And let me tell you something right now that you may not understand. Foreign trustees are plentiful and professionally qualified to administer offshore trusts. And there's never been one interest that they have ever displayed in my investigation of offshore trusts, of stealing any one, even one single penny from any trust that they administer. Most are chartered accountants or attorneys who have passed special examinations. have taken great pains to secure special education, specifically to administer trusts. There are also trust companies as well as banks, which are institutional trustees. They have no interest in destroying their reputation and losing all of the promising business that they have or may obtain in the future by stealing even one nickel from anyone. Beneficiaries are those who benefit from the trust and receive trust income and or assets. Whether it's today, next week, next month, next year, 10 years from now, 25 years from now, or 100 years from now. Those whom you want the trust to benefit are the beneficiaries. Now there's several different types of beneficiaries. Those whom you want the trust to benefit during your lifetime, or who will inherit the trust assets after your death, are one kind. They can be either named or unnamed. You can name individuals or name a group or class, such as all surviving children. Not only can you designate the beneficiaries by name or class, but they can also be profit or non-profit corporations, or foundations, or organizations, or partnerships. Other trusts are any other American or foreign legal entity that you can possibly think of. An unnamed beneficiary can be a bearer beneficiary. The trust can issue bearer certificates with no name, and whoever holds the certificates in their possession are the beneficiaries of the trust, and they will be the beneficiaries of the trust as long as they hold that document, whether you are alive or dead, for the entire life of the trust. As the settlor, you can expand, contract, terminate, or shift beneficial interests at any time, subject only to the trustee's agreement. And if the trustee disagrees, you can't do it. And so when you set it up, you must have this in mind. You must do it in a manner that ensures that the trustee is going to agree with whatever your wishes happen to be. Now, the trustee can only agree to a certain point. The trustee can never break the law or go against the law to harm, damage, irresponsibly deplete, or destroy the assets of the trust, regardless of what your wishes may be. And the beneficiary, ladies and gentlemen, cannot ever live in Belize. The settlor cannot live in Belize, the beneficiary cannot live in Belize, and the protector cannot live in Belize. You may visit Belize, you may vacation in Belize, but you may not live there. You may not vacation for a long enough time to be qualified as a resident of Belize, because then you endanger your trust under the law. The protector is the individual, company, corporation, trust, partnership, or any other entity who oversees the trustee. You see, the trustee is not just there doing what they want to do. There is a protector of the trust. The protector, like the trustee, protects the intent of beneficiaries, the interest of the beneficiaries. The protector more specifically prevents misdeeds by the trustee. The protector can only veto trustee decisions that appear inappropriate by the trustee. The protector cannot force the trustee to undertake any act, but he can prevent trustee actions. And here's an example. Listen to me carefully. A trustee may require the protector's approval to sell investments or withdraw funds without the settlor's approval. In this case, the protector verifies the settlor's approval. The protector ensures that the trustee acts in best interest of beneficiaries. The protector's most important power is the authority to replace the trustee should the trustee get just totally out of hand. It is through the settlor's authority to change the protector and protector's authority to change the trustee that the settlor indirectly controls the trustee and the trust. You see, the protector receives a benefit in the form of some kind of payment for being the protector not just of one trust, but many trusts. It's their livelihood. The protector is there to make sure that the trustee does his or her job. If the settlor submits a list of wishes to the trustee that the settlor believes must be carried out in the best interest of the trust and the trustee refuses, the settlor can inform the protector of the trustee's actions. The settlor can take a look at it. And if he agrees with the protector can take a look at it, and if he agrees with the settlor, remember, he cannot make the trustee do anything, but he can prevent the trustee from doing things and can, in fact, change the trustee. The trustee does not want to lose his job. He doesn't want a black mark on his career. And if the settlor sees that neither one of these people are carrying out his wishes and they're reasonable and they are in the best interest of the trust and the beneficiaries, the settlor can change the protector for a protector who will change the trustee. I hope you understand how this works. Now you could, but I'm telling you right now, you don't want to be. You could be both the protector and the settlor. But that would open you up to liability because a U.S. court could decide that you control the trust, thus forcing you to turn over assets to satisfy creditors. In fact, in the United States now today, they're saying that if you're the settlor, you actually own the assets in the trust, and they're taxing you on that if they can find out what they are. That's why I'm telling you, you can't get away with having a trust in this country anymore. They're going after people who have trusts. And even though you may have been safe up to this time, and maybe for some time into the foreseeable future, at some point in the future, trusts will become illegal in this country. Now, if you don't believe they can do that, look what Hitler did in Germany, and I'm telling you right now, the United States of America is becoming the Fourth Reich. Whatever Hitler dreamed of will be done in this country. In fact, much of it is already being done. Foreign protectors place the protector beyond the reach of an American creditor's subpoena and the power to examine the protector under oath. You hear what I'm saying? A foreign protector is beyond an American court's power to subpoena him or her and bring them into court to be examined under oath. And even if they were, according to the laws of Belize, they cannot disclose any information about the trust. The protector cannot live in Belize in order to satisfy the requirement of being an exempt trust. But that's no problem. Just don't want the protector to be living in the United States of America. Now, how does the settlor communicate instructions to the trustee? Well, it's very simple, folks. The settlor sends a letter of wishes. You see, the settlor cannot tell the trustee what to do, and the trustee is not bound to obey anything that the settlor says once the trust is in operation, beneficiaries have been named, and the trustee is now in control of the trust. but the settlor sends a letter of wishes that contains the instructions or request. And it should always be in the form of a request, never in the form of instructions or an order. The settlor can, for instance, ask the trustee to send funds, request a change in beneficiaries, make new investments, request a loan to himself or another beneficiary, or appoint a new trustee or protector. While it appears that trustee has full control and authority, the settlor, in fact, has considerable control over the trust and the trustee. It is always in the trustee's best interest to take care of the settlor's reasonable requests. Now listen to what I said. Reasonable requests. If you're going to get crazy, forget it. Because by law, he could be held criminally liable if he does the wrong thing that goes against the best interest of the trust and or the beneficiaries. And he's not going to do it even if you replace him. But he will carry out any reasonable request that you may have. He has no reason not to. In fact, he has every reason to do it for you. Otherwise, he will find himself out of a job. Now, when it comes to offshore trusts, the most common question is, how do I know I can trust the trustee? Well, the way the trust is set up ensures it. After all, when someone, particularly a stranger in another continent or on some island, controls your money, you have a legitimate concern that the trustee may embezzle, squander, lose your money, or make bad investments. In fact, if you weren't worried about that, I would question your sanity. But in reality, there is very little basis for this concern. Foreign trustees are known to have absolutely impeccable track records for honesty and prudence. In fact, I have never heard of one instance where an individual has ever lost $1 to theft by a foreign trustee. In addition to the inherent honesty of the trustee, an offshore haven cannot afford an embezzlement scandal. You see, folks, they make their money on building confidence to attract foreign investors, foreign money. That's why they set up these laws. That's why they protect the trusts. It is good, and in many instances is the very foundation of their economy. And if for any reason a trustee should prove dishonest, the tax haven will move towards making quick restitution. In other words, the country will make restitution because they cannot and will not afford, nor do they want, nor will they allow the negative publicity to occur. Because everybody would bail out. Remember, they're all there to protect their money. That's the only reason they have their money and their trusts and their IBCs in that country. And if they see that people are having their money or their assets stolen, embezzled, they will bail. They will leave. By the thousands, by the tens of thousands, by the hundreds of thousands, they will bail with their money and go somewhere else. Do you see? Well, that's it, folks. That's it for tonight. I want to thank you all for listening. I want to wish you good night. God bless you. And Annie, Pooh, and Allison, I love you. I miss you terribly. I wish so much that we could be together. But you see, if I don't fight this battle, you may live a future life in enslavement. And I love you so much, I would rather not see you than ever believe that that's the kind of life that you were forced to live because I did not do what I was supposed to do. May God protect you and keep you safe. If you'd like to get a head start, folks, go to our website, harvest-trust.org. Click on the Belize Offshore Trust Program and start from there. I'll help you any way I can. If you keep listening to this broadcast, you won't need much help. You're listening to 101.1 FM Eager. It's an example of what a trust can do. You see, it's the charitable foundation trust of my children. You're listening to the Hour of the Time. I'm William Cooper. Welcome, ladies and gentlemen, around the world to, I believe this is part 4 of our ongoing series on asset protection. Now, if you want to get way ahead of the game, go to our website. It's harvest-trust.org. That's harvest-trust.org. And click on the Belize Offshore Trust banner there and start reading. Just follow all the links and start reading and studying, and you'll learn quite a bit. You won't learn as much as you're going to learn listening to this broadcast, or if you send for our report. The report is $50. If you'd like to have a copy of everything that I'm giving you on the internet, not on the internet, but on this broadcast last week, tonight, and a couple more nights, and maybe even after that, send $50 to the Hour of the Time in care of 101.1 FM. That's the Hour of the Time in care of 101.1 FM. P.O. Box 940. That's P.O. Box 940. Eager, spelled E-A-G-A-R, Arizona, 85925. Once again, the Hour of the Time, in care of 101.1 FM. P.O. Box 940. Eager, spelled E-A-G-A-R, Arizona, 85925, USA. The information that you're getting on this broadcast applies in any country, anywhere. So pay very close attention, folks. You want to make sure that you get this information. Along with your report, you will also get the, whoops, got a little ahead of myself there. You'll also get the information you need to make application if you want to join the Belize Trust program. It's up to you. I highly recommend it. This nation is quickly becoming the Fourth Reich. Nothing that you have is safe in the United States anymore. If you think it is, well, stick around. You're going to find out the hard way. The hard way. We're headed into full-blown socialism. And socialism doesn't let you have anything. You have to be a victim. You have to be poor. You have to be one of the downtrodden masses. They must eliminate the middle class. You can't own property in a socialist state. And so they're going to take it all away from you, and then Big Brother is going to promise to take care of you and your children and all of that kind of stuff that we have seen in the past. Socialism never, ever does. They kill, murder, put people in prison, concentration camps, labor camps. Socialists are responsible, as a group, for the largest number of people murdered in the history of the world by any one group. So if you think you like socialism, stick around. You'll change your mind real quick. Even the people who love socialism, who usually bring socialism and communists to power, always find out that they made a big mistake. They're usually the first ones executed. And, if you don't believe me, look it up. It's all there for everybody to see. It's a matter of historical record. Yes, again, say that again. But will they? How does the settlor communicate instructions to the trustee? I'm backing up just a little bit, maintain the continuity of what I'm teaching you here. Well, folks, it's very simple. The settlor merely sends a letter of wishes. So he cannot order the trustee to do anything, but he can submit a letter of wishes that contains the instructions or request, and it should always be in the form of a request, never instructions or orders. The settlor can, for instance, ask the trustee to send funds, request a change in beneficiaries, make new investments, request a loan to himself or another beneficiary, or appoint a new trustee or protector. While it appears that trustee has full control and authority, the settlor, in fact, has considerable control over the trust and the trustee. So it is in the trustee's best interest to take care of the settlor's reasonable requests. The key word there is reasonable. Otherwise, the trustee will be out of a job. Now, when it comes to offshore trusts, ladies and gentlemen, the most common question is, how do I know I can trust the trustee who lives in that foreign country and I've never met him before in my life? After all, when someone, particularly a stranger in another continent or some island somewhere, controls your money, you certainly have a legitimate concern that the trustee may embezzle, squander, lose your money, or make bad investments. And if you didn't wonder about those things or take steps to answer those questions, then you certainly would not be responsible and you would not be practicing due diligence in the efforts to protect the assets. And that you must do, always. In reality, there is very little, absolutely very little, and in my experience, no basis for any of this kind of concern. Foreign trustees are known to have impeccable track records for honesty and prudence. In fact, I have never, and the Belize Trust Program has never heard of one instance where an individual has ever lost $1 to theft by a foreign trustee. I can tell you personally that our family has never even lost a penny. The trustees that we deal with have been absolutely the most responsible businessmen that I think I've ever dealt with in my life. In addition to the inherent honesty of the trustee, an offshore haven cannot afford an embezzlement scandal. You see, they make their money, ladies and gentlemen, by building confidence in order to attract lots and lots of money from other countries to their shores. And a lot of people make their living because of that. The country's economy thrives because of it. Because a lot of that money, those investors choose to invest in projects in that country. If for any reason a trustee should prove dishonest, the tax haven country itself will move towards making a very quick restitution because they can't afford. They don't want to even hear it. They don't want the negative publicity. They don't want to drive the money away from their country. They need it. So, check it out carefully. And once you've reached the understanding that these things just don't happen, and if they should, perchance, you're not going to lose anything. Nobody's going to let that happen. Your next question might be, what happens when I die if I'm the settlor of this trust? And of course, I'm advising you not to be. There's ways to do this so that you're not the settlor, the protector, the beneficiary, or the trustee, and still can maintain control. And I'll be talking about that before I'm done. One of the greatest benefits, ladies and gentlemen, of an offshore trust is that it is air conditioned. That's spelled H-E-I-R. Heir, as in your children. Normally, upon the death of the settlor, the assets will be distributed according to trust provisions. The final beneficiaries and method of distribution are kept on record through a letter of wishes or a series of letters that reflect changes. The trust ordinarily provides that it will dissolve upon settlor's death, or after a certain number of years the assets will go to the remainder of the beneficiaries. If you really want to make this work, I recommend that your trust be in effect for the maximum number of years allowed, which in Belize is 125 years. Well, what if you don't want it to last that long? What if you want your heirs to take over and receive all the benefits? Or what if you want your heirs to take over and control the trust after you're dead? And you do want the trust to go on in operation for the maximum number of years, or a set number of years, beyond the time of your death. Well, if your heirs are the beneficiaries of the trust, there's no change needed. You see, the successor trustees takes over and conducts business as usual. If your heirs were not the beneficiaries at the time of your death and would like to be afterwards, the present beneficiaries need to relinquish their position and have it cleared by the trustee. Now, you might have some difficulty doing that, so you want to make sure that all of the specifications of who is going to be the beneficiaries of the trust are clear before you die. So you have to take care of all that through your letters of wishes to the trustee before you kick the bucket. One of the best ways of doing this is by having bearer certificates. In other words, whoever holds the certificates is the beneficiary. Or if there's more than one beneficiary, there would be more than one certificate. Or there may be one certificate entrusted to 2 or 3 or 4 people. However you set it up is the way that it will work. If your heirs simply want to control the assets like you did before your death, you will need to make sure their names are established as successor trustee in the appropriate minutes. That way, in the event of your death, they automatically take over your position as first trustee. Now, what is a trust certificate unit and TCU, or trust certificate unit holder? Well, it's very simple, folks. A trust certificate unit is similar to a stock certificate in that it represents ownership to an asset or a group of assets. A trust may have any number of certificates issued. The settlor designates exactly how the trust certificate units are divided, and whoever holds them are the beneficiaries of the trust. The trust can be issued one bearer certificate to be transferred to the beneficiary of your choosing upon your death. And during your lifetime, there really doesn't have to be a beneficiary. You can just hold that certificate until you die and then specify who it's going to go to. Nothing is actually transferred to whomever you may name in your will except that certificate. And unless there is a disbursement of the assets of the trust to the beneficiary, there's absolutely nothing to tax. It's also a good idea if you pass it along without anybody knowing that you've done it. And there are ways to do that also. Now, listen to me very carefully. A trust is not a bank account. It's not an investment account. You see, none of the assets belong to you once you place them in the trust. Now, somebody like the IRS, if you're the settlor, the trustee, the protector, or beneficiary, and you're the one who put those assets in that trust, they're going to try to say that they really do belong to you, and they're going to try to tax you on it. And this is one reason why I'm telling you it's not good to be one of those things. The trust does not have a return until funds are invested by the trustee at your request. A trust is not usually registered or recorded, and I advise you strongly never to register or record your trust. A trust has no reporting or accounting requirements, none whatsoever, and it is not required to be registered or recorded. The assets are not subject to taxation until a disbursement has been made. Assets not subject to probate are estate duties. So when you die, you don't lose most of what you accumulated in your lifetime because of death taxes and inheritance taxes and lawyers and contested wills and all of these kinds of things. You may die, but the trust continues to live. And remember, the trust in the law is a person. A trust does not need an attorney or an accountant to set up the trust. Not required. It is not required, ladies and gentlemen. Now, how can an offshore trust protect your assets? Well, quite simply, the very same way that it has protected the assets that this family has accumulated throughout its lifetime. I own nothing now. Everything is in trust. Even though there is a warrant out for my arrest by the federal government in an attempt to shut me up because I've never broken the law, at least not intentionally, and I've never committed a felony or anything like that. Almost everybody in this nation has committed a misdemeanor at one time or another. A traffic ticket is a misdemeanor. A parking ticket is a misdemeanor. But the jackbooted thugs have never succeeded in even taking one single penny that belonged ever to this family. This family owns nothing now. Now, you wouldn't have those kinds of problems because you're not on the radio telling the truth that hurts these stinking, rotten, treasonous socialists who want to destroy this country and bring about their utopian world. You're not hurting them like I am. No one in the history of their attempt to take over this country has ever hurt them like I have done. I'm the only one who has ever been named as the most dangerous enemy to their cause. The only one. So it's only natural that they come after me, and I told you many years ago that they would. I was prepared for it. I'm prepared to die, if need be, in this battle, and it is a battle, it's a war, in order to make sure that my children can live free in the future. You don't have this problem. And if you keep your mouth shut, you do this right within the law, and you keep your assets out of this country so that they cannot take them, you'll be fine. Try to do it any other way, ladies and gentlemen, and sooner or later you're going to lose it all. Most of you have already arrived at that conclusion without my help. But even if everything were fine, to own property today in this country in today's litigious society is a liability. The government wants you to own property because it is in their best interest and a major source of tax dollars. Attorneys will tell you about living trusts and wills, but they don't want you to know about benefits of an offshore trust because it eliminates the need for probate. And that's one of the biggest sources of incomes for attorneys. It also shelters your assets so it becomes unprofitable for attorneys to sue you. In fact, an attorney will never take a lawsuit against someone who has no money and no property, because he knows that even if he wins, he will not be paid. Not one red cent will he get. Neither will his client or her client. An offshore trust discourages litigation in 3 ways. Listen to me very carefully. First, it provides secrecy. Nobody's going to know anything about it unless you open your big mouth. Unless you have a disease known as flapjaw, and it's terminal. A trust provides secrecy. The creditor or plaintiff in a lawsuit doesn't know how much money you have, which usually stops many potential lawsuits before they start. And even if they thought they knew how much money you have, you really don't have it. And this is what you have to get through your head. You don't own it. It belongs to the trust, not you. Second, an offshore trust will convince even the most determined plaintiff that it would be difficult, if not impossible, to collect, whether they won or not. And I'm telling you right now, they wouldn't be able to collect at all, except if they could find trust property in this country. And they're not going to do that unless, once again, you have flapjaw, a terminal disease that wipes so many people out. I was talking to a judge one time, a real federal judge who was honest with me in private, but would never repeat anything that we discussed, and, none of the honest things that he ever admitted in public. And I said, if all of this is true, why are there so many people in prison who should not be there? He said, Bill, there's not one single person in prison who did not volunteer to go. Well, that shut me up for a while, because I was pushed way down in the depths of deep thought when he said that. It took me a while to really understand what he was talking about. Flapjaw is exactly what he was talking about. Dealing, plea bargaining, not trusting the jury. Giving them, by opening your mouth and talking, all the information they needed to put them in prison. Well, if you can keep your mouth shut, the asset protection of an offshore trust levels the playing field. The defendant gains bargaining power and leverage because the plaintiff cannot collect. And remember, you don't own anything. The trust does. You're not ever going to be the defendant. The trust is going to be the defendant. Since the trust is offshore, they cannot subpoena the trust or the trustee to come into a court in this country and testify. The offshore trust gives you leverage to settle for pennies on the dollar if you choose to do so. I, of course, would never do that. Now, there's a big portion of this that has to be governed by morals and ethics. You should not, and I'm going to say should not because I know damn well there are some people out there listening who would, because they're selfish and greedy and don't give a damn about anyone else. And the only reason they would enter into this would not to be passed down anything to their posterity, but to preserve it for their greedy little selves while they're alive. We all know people like that. You should never use a trust to keep from paying debts that you lawfully entered into and lawfully owe. You should never use a trust to get out of a contract that you knowingly signed and committed yourself to with no fraud perpetrated against you. If you hurt someone and you know in your heart and soul that it was your fault, you should not use a trust to get out of taking care of that person that you hurt. So understand what I'm telling you, even though I know most of you aren't going to pay any attention to that at all. Third and most important, a judgment creditor cannot seize your assets under any circumstances. A judgment creditor cannot seize your assets under any circumstances, and that goes for the jackbooted Nazi, lying, outlaw, criminal thugs of the Internal Revenue Service. Traitors all. Scum of the earth. And this also applies to the beneficiaries. The beneficiaries' creditors have even less power to reach assets because the beneficiary has no vested interest in the trust. And if you do this right, neither will you. In the event the beneficiary becomes insolvent, or any part of his property becomes liable to seizure or sequestration for the benefit of creditors, the trustee has the right to minimize the beneficiary's interest in the trust. This is designed to protect the beneficiary against his or her own incompetence or inability to handle money or property. For added protection, the trust has a spendthrift provision that prevents the beneficiary's creditors from seizing undistributed assets. And how could they anyway? If they're undistributed, they belong to the trust, not the beneficiary. Nothing belongs to the beneficiary. Nothing is taxable or seizable or probatable or anything else until it has been dispersed to the beneficiary from the trust. An offshore trust is also the safest alternative if somebody is already after your assets. The fact that creditors know about the trust will not give them claim. A court cannot touch assets in an offshore trust, even though the American settlor debtor is under court provisions. Even though the court knows about the assets, the court still cannot compel a debtor to do what the debtor has no legal power to do. You see, the assets belong to the trust. Only the trustee has the power to hand over assets to anyone. Only the trustee has the power to return assets titled to a trust. By the terms of the trust, the settlor, as judgment debtor, cannot compel the foreign trustee to return assets and therefore cannot be held in contempt of court for failure to do so. Even if he tried, the trustee would not allow him. So if somebody is already after your assets, there are many ways to protect yourself with an offshore trust. You can loan yourself back your own money. And actually, that's wrong. You can't loan anything. The trustee can loan you money that belongs to the trust and encumber your assets to secure payment. This loan can be interest-free. You see, we have a right to contract whatever we wish. You could take a second mortgage loan from the trust with payments so high and repayment terms so unattractive that creditors would not pursue your home. Since you indirectly control the trust, you can adjust the loan in many ways. In other words, there could be such a debt placed upon your assets owed to the trust that nobody is even going to try to take them. Another way is to borrow money from the trust through a shared appreciation mortgage. You borrow money from the trust and agree to repay the loan at a lower rate of interest in exchange for the trust receiving a share of the pledged property's future appreciation. The profits eventually go to the trust and are tax deductible to you, and are the profits eventually go to the trust and are tax deductible to you, and are tax deferred until your death. In the meantime, the shared appreciation mortgage shields future equity buildup from creditors. See what possibilities there are? Does your business have accounts receivable? You could sell them to the trust at a discount. Now, you can't sell it at a greater discount than it is normally accepted in business, because then the IRS will say you gave it to the trust and therefore it was an unlawful and not standard big business practice to do that. That's why I always warn you, everything must be done according to real value. Now, in business, they really do sell accounts receivable at a discount, and it's called factoring. Factoring. If you sell them for 50 cents on the dollar and you have $10,000 in receivables, your business will receive $5,000. When the receivables are collected, the trust will have $10,000, which gives the trust a non-taxable income of $5,000. The possibilities are endless. Keep in mind, folks, that it is fraudulent to transfer assets after legal action has been undertaken. But if you know that legal action is going to be taken, it is not illegal, it is not illegal, it is not fraudulent to take action and transfer assets before the legal action has been filed. However, even under the circumstances of after legal action has been undertaken, the court still cannot compel the settlor debtor or the trustee to remove the assets from the trust, but they can prosecute you if you broke the law and transferred the assets after you knew legal action was undertaken. But even though they may be able to prosecute you for that, they cannot touch your assets. The offshore trust breaks the chain of legal ownership between the settlor and assets. So you don't own it anymore. It's not your money. It's not your property. It's not your home. It's not your car. None of it belongs to you. And the anti-duress clause in a trust further provides that the trustee must ignore any request from the settlor or beneficiary that is made from a court order. The creditor or plaintiff could try to file claim in the tax haven, but the laws of such places are structured in such a way as to make it difficult, if not impossible, to collect. Even if a creditor were successful, the trustee will evoke the flight provision feature of the trust by exercising his or her right and moved the trust to a new haven, and it can literally be done within an hour on a computer, forcing the creditor to begin legal action again. And legal action offshore, ladies and gentlemen, is expensive. You have to have a lawyer here who must contact a lawyer in that country, who must locate the assets, find out where the trust is, who the trustee is, bring the action in the court, and it's all done through your attorney here. If you think it costs a lot to sue somebody in this country, try suing somebody outside this country. That's why you never hear of things like that happening. So as you can see, an offshore trust is your best legal alternative to protect yourself without illegally concealing your assets. Don't ever do anything illegal or unlawful. Stay within the bounds of the law. And I'm talking about the law. I'm not talking about the color of law. Stay within the law, and you'll be fine. With a trust, you can be both truthful, ladies and gentlemen, and safe. What about bankruptcy, you may ask? How does an offshore trust affect bankruptcy? It is essential, ladies and gentlemen, to truthfully report to the bankruptcy court all recent transfers to a trust that you may have an interest in. Now, the key word is that you may have an interest in. If you're not the trustee, the beneficiary, the protector, or the settlor, you have no interest in that trust. The assets do not belong to you, even though you transferred them. And if you don't occupy one of those four positions, you have absolutely no interest in those assets whatsoever. Dishonest reporting in bankruptcy is fraud. On the other hand, a bankruptcy court has the same recovery powers as an individual creditor. As long as there are at least two or more discretionary beneficiaries of the trust, the trustee is under no obligation to distribute assets to the bankrupt beneficiary, assuming you are one of the beneficiaries. A bankruptcy court cannot compel the trustee to turn over assets transferred to the trust under any circumstances for any reason whatsoever. Period. Can the IRS seize assets in an offshore trust? Well, ladies and gentlemen, the manner in which the IRS treats the United States of American citizen and the separate citizens of the several states has done more to encourage taxpayers to move their assets offshore than any other factor. And if I had not discovered the terrible tyranny of the Internal Revenue Service long before they ever came after me, I would never even have thought about putting my assets in a trust. But I began looking for ways to protect our assets as soon as I discovered there was no law that required us to file and pay the income tax in the first place. Congress has never passed such a law. No such law exists. We're just simply not bound by law to participate. And I'm not going to. So it's mainly because of the IRS that there is a great, huge, burgeoning, and successful offshore business in investments, asset protection, trusts, international business corporations, and I could go on and on and on and on. You see, the position of the Internal Revenue Service jackbooted Nazi thugs is you're guilty until you're proven innocent. And that has ultimately undermined and destroyed American patriotism. What is the government's response? Expand the authority of the Internal Revenue Service. Taxpayers, if you call yourself a taxpayer, you're a fool. If you belong to something called the Taxpayers Party, you're even a bigger fool. Because in the law, you are what you call yourself. Citizens with serious Internal Revenue Service problems frequently sell or mortgage their assets and then transfer their liquid wealth to the offshore trust before a tax lien is levied. And ladies and gentlemen, I've investigated these IRS tax liens. They have never levied a lien in their history. They fool the county recorder by filing a notice of lien. A notice of lien is not a lien. Only a court can make a judgment and place a lien on a property. The IRS does all of this hocus-pocus magic bullshit act under color of law, without due process, without a court order, with nothing. They do not file actual liens. No lien exists. What they file is a notice of lien with the county recorder, who's just another dumb sheeple and doesn't know the difference, and therefore is part and parcel to the conspiracy to destroy you and your property. And it usually is your next door neighbor. Oh, it's old Mrs. Harris, been working for the county for 40 years. She's just such a sweet little thing. Too bad she's so damn ignorant. Sweet little thing, my butt. When she's doing things that destroy families and businesses and lives, she is not a sweet little thing. She is an ignorant, stupid clerk sheeple, participating in tyranny. So no lien is ever filed or levied. It's a hoax. If you don't believe me, check it out in the law yourself. I've already done it. Makes me sick, makes me angry. So the only way your assets are safe from the Internal Revenue Service is to be sheltered offshore. They can't touch them there. A safe tax haven will not enforce Internal Revenue Service levies or summons or cooperate with the IRS to discover or seize trust assets. And this is why it is important that the trust be located in a foreign haven that does not have reciprocal agreements with the United States. Could it happen to you? You betcha. It's going to happen to somebody listening to this broadcast tonight. You see, there's a lot of people who mistakenly believe that if they have a corporation, they're safe from judgment and creditor claims. And haven't we all at some times in our life said, well, it can't happen to me? Even if you have a corporation, your personal assets may be seized to satisfy an Internal Revenue Service judgment against your corporation. Did you know that? You could lose your home, automobile, and all your personal possessions. They do it under the color of law, unlawfully, unconstitutionally, but nevertheless, they do it. Hitler lives, ladies and gentlemen, in the United States of America. That sucker never died. He just got in a rowboat and came over here. Roughly 2/3 of the owners of United States corporations are sitting ducks for this sort of legal action, and you don't even know it. The sudden seizure of your assets could result in something as simple as failing to keep complete corporate records. And you may not even have anything to do with it, may not even know the employee who does. And there may be a chain of managers between you and that employee that you must trust somewhere along the way to make sure that things are done right. Let's look at an example. Someone brings a frivolous lawsuit against you and your corporation, simply because they know there's some money there, and they know to keep from spending years in court and hundreds of thousands of dollars in legal fees, at some point along the way, you're going to offer to settle with them, because that's what most people do. Wrongly, no one should ever settle, but they do it. Their attorney subpoenas your corporate records, or during a routine IRS audit, the auditor asks to see your corporate records. And like a fool, you give it to him. Just because he asks to see something doesn't mean that you're required to turn it over. In fact, you're not. In both cases, your corporate records are not up to date, or they may be incomplete. At that point, it is too late to fix them up. As many people try to do under such circumstances, you're in trouble. Now, here's a worst-case scenario. The IRS pierces your corporate veil, denies tax benefits, and socks you with a huge tax bill. You can be ground up like sausage. You can't pay, and they file a notice of tax lien. Notice I said notice of tax lien, because that's what they file. They really don't have a lien. The county sheriff doesn't know the difference between a real lien and a notice of tax lien. And he goes out there with them to take all your property. Another stupid sheeple fool. That's how people who start out to do good end up doing terrible damage and harm to their neighbors, because they're ignorant. And even if somebody presents them the truth, they don't want to hear it, and that makes them stupid fools. They file a notice of tax lien. And of course, everybody in the county goes right along with it, because they don't know the difference between a real lien and the notice of tax lien filed by the Internal Revenue Service. And they take all your property, real and personal. You try to borrow money to pay the bill, but all of a sudden you find your credit rating has evaporated overnight because of the tax lien. Your bank account is attached, regardless of how many checks you have outstanding. And then when they come in, guess what? You've bounced checks, and now you've committed a felony. Oh yeah, It doesn't make any difference in the law why they bounce. You're not supposed to bounce checks. And you can go to prison for that. On top of all the IRS problems, most women, when a husband finds himself in that situation, will leave him and divorce him and take his children away from him. Now, I'm not saying all women will do that, but most women will do it, have done it. It happens every day. They put a lien against your outstanding investments, or a notice of lien, I should say. They have never, ever secured a proper lien. And bankruptcy does not stop them. Your salary and your spouse's salary are garnished. This is usually when the wife decides she's leaving. I'm leaving. So much for marriage vows. They obtain a writ of entry and seize your safety deposit box. You didn't think they could do that, did you? But they can. They eventually grab your IRA or other retirement plan and the cash surrender value of your insurance. Without notice of foreclosure, your real property and liquid personal property could be sold with no minimum bid whatsoever for pennies on the dollar. And if that doesn't pay the bill, the Internal Revenue Service will attach your pension, and they will follow you and snatch every penny you ever earn out of your hands before you can even put it in your pocket. Sound like a horror story? Well, it is, and that it's not even all. You see, if you're clever enough to try to end it all and protect your family from further seizure and die or commit suicide, they will come after your estate after you're dead. They will even take the family photo album. They'll take the children's piggy banks, dolls, and toys. You don't think so? Ask somebody who has been through it. They do all of that and more. You better understand, ladies and gentlemen, this is not the United States of America we were taught that it was when we were children. And I'm 56 years old, so I was a child a few years ago. What I was taught about this country was totally different from what I see that it actually really is today. This is not the United States of America that I was promised. This is not the United States of America that the founding fathers built. This is not the United States of America that all of the patriots who have died for freedom and for this country in its history fought and died for. We're about 1 inch away from the most terrible despotic tyranny that you can imagine. And for many people, it is already here. Now, as with bankruptcy, all asset transfers to a trust and legal or beneficial interest in a trust must be disclosed to the Internal Revenue Service according to their color of law, Nazi jackbooted thug tyranny regulations that have no force of law whatsoever when it comes and when it attempts to enforce collection. However, even if they know about it, they still cannot seize the assets, nor can they force you to remove assets in an offshore trust under any circumstances. And remember, if you're not the settlor, the trustee, the protector, or a beneficiary, they can't even try to come to you to get you to disclose any of it or enforce any collection, because none of it belongs to you, and they can't connect you with it at all if you are not in one of those four positions. then you couldn't give them anything anyway. It doesn't belong to you. Even if you are in one of those four positions, only the trustee can disperse or move or give over assets of a trust. You no longer own the assets. The trustee owns the assets in trust for the trust and controls them and will not allow them to be seized under any circumstances, and the laws of the country, if you choose properly, Belize is your best choice, the laws of that country will protect the trust and the trustee against any attempt And did you know that your business can be a trust? Now, I've met some sheeple in my life, and socialists are the biggest sheeple I've ever seen. I mean, they are just, their brains have vacated their head. And the first thing that they will ask is, why do I need all this secrecy if I have nothing to hide? Privacy, folks, is a dirty word to socialists. It's a dirty word to bureaucrats, too. Consequently, it's virtually extinct and unavailable in the United States today. You would be absolutely amazed what they know about you. In fact, you would be amazed what I can find out about every single one of you listening to this broadcast without exception just by spending 1 hour on my computer. You would be amazed. In fact, it would scare you. You see, the government of the United States neither respects nor guarantees your privacy. Your private records are not protected. Our debt-ridden government wants a bigger bite of your wealth so it can search harder and harder and harder each year for more dollars, for more taxes to confiscate from you and your family and use any excuse, including national security and crime prevention and drugs, and to invade your financial property and just take it all away. If they thought they could sell you and slavery was legal, they'd take you too. If there was a slave market, they'd sell you there if they could get away with it. Your financial records can be subpoenaed. Of course, you don't have to turn them over simply because of the Fifth Amendment. But they can be subpoenaed not only from you, but from your bank, and that's a third party, from an accountant, from your CPA, from your bookkeeper, from your investment broker or financial planner, or anybody else who knows anything about them. See, only you, if you're accused, can cite the Fifth Amendment for not turning anything over that might tend to incriminate you. And I can hear the socialists say, well, if you're not guilty of any crime, why would it tend to incriminate you? Oh, little do they know. The United States government has at least 30 active files on each single person listening to this broadcast and every other person who lives in the United States of America as a typical American or resident alien. If you're a high-profile individual like me, they may have hundreds of files which they freely share with anyone who wants to know. So think about your income tax. Think your income tax information is confidential? Well, think again. New rules, ladies and gentlemen, enable the Internal Revenue Service to hire outside contractors to process tax return information. The new rules state that providing tax return information to outside companies will not violate taxpayer confidentiality. Common sense says that anyone other than the IRS who has access to your tax return has the ability to do whatever they want with them. How about that? How about them apples? Ladies and gentlemen, good night, and God bless each and every single one of you. God bless you, Annie, Pooh, and Allison. I love you. May God keep you safe. Now you know why President William Jefferson Clinton called me, William Cooper, the most dangerous radio host in America. Oh, man, they hate it when I teach you stuff like this. They can't stand the truth. Makes them run for cover. It's like turning the light on and all the cockroaches and bugs and spiders slide and slip and slime back under the refrigerator. Well, that's what we do here. We illuminate the cockroaches, make them scurry for cover. Don't forget to tune in tomorrow night for part 5. You're listening to 101.1 FM Eager, classic radio like you always wished it could be. A lot of truth mixed in there too, and a lot of the very best music of all of the generations gone by.